Good morning. My name is Shari'a and I'm the Dean of Chicago, Kent. On behalf of our whole community, I want to welcome you here this morning. Shari'a and Halakha play such an important role in individuals' lives in many different respects. But the question is, what role does it play within our civil society and our pluralistic religious background? It's not an easy question. Tensions abound. That's why I'm so glad that UIC and Chicago, Kent have brought everybody together to sort of explore this idea, both on a cultural and a legal plane. I want to thank in particular Sam Fleischheimer from UIC, who started a Jewish-Muslim initiative about 10 years ago, if I remember correctly. 8 years ago. Time flies, Sam. And also Mark Rosen of my own faculty, my colleague, who is spearheading from our side this particular conference. It's a fantastic conference. I think we'll all benefit from it. And I want to finish by thanking the Jack Miller Center for helping to defray some of the expenses. And we may see Jack may even show up later today himself. So with that, Mark Rosen, thank you.
Thank you all for coming here, and thank you to Junaid Qadri as well for putting this conference together. So we have three terrific speakers on our first session, and I'll introduce them one at a time. Each will give a presentation. Thereafter, I'm going to give an opportunity for them to speak among themselves, ask any questions, and then I'll take any questions that you might have. Okay. Our first speaker is Tim Lytton, who is the Albert and Angelo Farone Distinguished Professor of Law at Albany Law School. He teaches towards administrative law legislation, and he studied both undergraduate and law degrees from Yale. He's the author of multiple books, including most recently a book called Kosher, Private Regulation in the Age of Industrial Food. And with that, we're going to move to Tim.
I want to thank the organizers for inviting me here to the conference. It's really a pleasure to be here, and I look forward to learning more about some of the commonalities and issues facing Jewish and Islamic legal systems in a liberal environment. I want to talk a little bit today about religious legal autonomy in the liberal state, and I want to start with a case study of private regulation in the American Kosher food certification system. So my thesis is the following. Religious liberty and free markets are two principal features of the liberal state. And these two features of the liberal state undermine forms of religious communal self-governance that rely on state backing. At the same time, these two features of the liberal state nurture entrepreneurial forms of private religious regulation. So this can be seen in the failure of 1,000-year-old Kahila model of kosher regulation and the success of an alternate version of religious regulation, which is a competitive system of private kosher certification agencies. So let me start with a little bit of background of what I'm going to call the Kahila model of communal regulation. Communal governance in the old world was characterized by a particular type of institutional arrangement. Civil authorities throughout the diaspora granted Jewish communities autonomy, which was often characterized by full powers of internal legislation and governance. Governance by the community council, or what was known as the Kahila, often included civil and criminal jurisdiction, as well as administration of standard municipal functions. Kahila legal authority was comprehensive and exclusive, by which I mean it covered the full range of internal administrative functions, and all the Jews in a particular locality fell under its jurisdiction. Now, the Kahila governed a number of different aspects of Jewish life, and central among them was the production of kosher meat or kosher slaughter. In each area where the Kahila had jurisdiction, a ritual slaughter or shochet was appointed and employed by the Kahila to perform ritual slaughter on kosher meat. Meat dealers seeking kosher slaughter would have to pay not the kosher slaughter, the shochet, but the Kahila, the governing body, which would then pay the shochet a standard fee regardless of whether the animal turned out to be kosher or treif non-kosher. The job of the shochet was a valuable asset that included exclusive rights to slaughter, tenure, retirement benefits, and transferability, and all of these things, this job security and the ability to use the position as a form of property, operated in order to make the position of shochet extremely valuable. And so the Kahila regulation made the shochet's job and position so valuable that that actually created an incentive for the shochet to maintain high standards and to avoid any risk of wrongdoing that might lead to dismissal. Now, in America, there was a failure to be able to translate this Kehillah model of communal regulation into the American context. American Jews attempted to establish the Kehillah system in America in the form of what's been known as the synagogue community. Each locality in America in colonial times and in the early 19th century had a single congregation which was run by a lay board which hired the community shochet. So instead of a Kehillah, you had a quasi-Kehillah structure which was the community synagogue, and the synagogue community became the administrative structure for self-governance. So each synagogue community exercised exclusive jurisdiction and monopoly power over kosher slaughter and meat production in their own jurisdiction, just like the Kehillah model. This all began to break down starting in 1813 with the emergence of what I'll call the independent shochet. Essentially what happened is, New York City had one congregation known as Shari'a and Halakha, and they hired a community slaughter. They actually had a series of them. And one of them turned out, a man named Abrahams, not to work out so well. He worked for 10 years, people were not pleased with his performance, and the community fired him. Now what he decided to do was to set up shop with the local butcher and sell his meat independently. So immediately the community leaders went to the City Common Council of the City of New York. They said, we basically want a decision that says that we are allowed to issue exclusive licenses for kosher slaughter in the City of New York, and this guy needs to go out of business. You should not be able to sell any meat in the City of New York that's not under our auspices. And the Common Council provided them an exclusive license, or exclusive power to license slaughterers. Well, Abrams did what today we call lawyering up. He got a bunch of congregants who were interested in buying his meat. They went back to the Common Council and they argued that in America you can't do this. The First Amendment protects people's rights to sell kosher meat wherever and however they wish, and for people to buy that meat. And as a result, for the first time, there was a slaughterer who no longer worked for the community. The slaughterer now worked for the slaughterhouse or the butcher. The slaughterer was now an independent contractor. And that independent contractor was now in the pay of people who had a financial interest to make sure that the meat was kosher, and in some sense would create pressure to lower standards on meat production. There were three other issues that created problems for communal control of kosher supervision, and I'll just briefly touch on them. One of them is the proliferation of synagogues, so you had multiple authorities within every jurisdiction. Another is Jewish population growth, so that simply the size of the market outgrew the capacity of a single congregation to be able to regulate. And finally is the development of a mass market in kosher meat, which also was just way beyond the ability of any single synagogue or Kehillah structure to regulate. So to give you some idea, here's some population figures for the proliferation of Jewish congregations in New York City from colonial times to 1918. In 1750, there was only one congregation in New York City. By 1855, there were 20, and by 1918, there were 826 separate congregations. Growth of New York City's Jewish population. In 1750, in Shari'a and Halakha, there were about 350 Jewish people counted in the congregation. By 1859, that number had risen to 40,000, which was already a stress on the community synagogue system. By 1880, it was 80,000, and after the great waves of immigration at the end of the 19th and early 20th century, in 1915, there were 1.4 million Jews in New York. This is far beyond what the Kehillah system in the old world ever contemplated for religious autonomy. The proliferation of kosher butchers is similar. In 1902, there were 1,500 kosher butchers, which is already an unwieldy amount of businesses to regulate for a communal structure. In 1950, that number grew to 6,000. By 1930, there were 7,500 independently operating kosher butchers. By 1887, already, with these independent shochets, there was widespread corruption in kosher meat production. And a Lower East Side Rabbi Moses Weinberg, who wrote a memoir, provided a grim portrait of the New York City kosher meat business in 1887. He wrote, "Shoftim and butchers, upon whose shoulders rest all responsibility for the laws of kashrus, are perfectly independent here. Neither they nor their work is inspected. The work of shechita, ritual slaughter, here is just like all other jobs. It can be undertaken by anyone who finds an opening. No longer did you need an exclusive license from the Kehillah. As far as the butchers are concerned, any slaughtered fowl with blood removed is marketable, even if the shochet admits that he's slaughtered totally impermissibly. And finally, among shoftim, absolute anarchy reigns, and butchers live in a world of lawlessness." By 1940, the same themes were being sounded by other commentators. Legal commentator Jonas Simon wrote in the early 1940s, "The kosher meat business is a gigantic fraud perpetrated on the well-meaning masses of people who pay a good price for kashrus but never get it. A wholesale robbery of the Jewish community. And to give you a sense of the scope of the problem, the New York City Department of Markets estimated in 1925, upon conducting a study, that 40% of the meat sold as kosher in the city was actually non-kosher. And if you think about that in terms of any other consumer product, that's an extraordinary rate of fraud. Furthermore, trade associations estimated the figure at closer to 50 to 65% of fraudulent meat. Now, there were a number of attempts to try and replace the Kehillah structure with some other regulatory instrument, and all of them failed for a number of different reasons. The first one was to reestablish communal control by a coalition of congregations, to create some sort of coalition version of the Kehillah. And this tended to fail because rabbinic rivalry, and those of you who live in rabbinic or in religious communities of any variety will be well aware of this problem. Rabbinic rivalry led to an enormous amount of backbiting and undermining, and it became very difficult to establish a working coalition over time. Industry self-regulation by trade associations was also attempted, but of course the inherent conflict of interest of people who were in the job of trying to profit off of the sale of kosher meat as well as maintain standards of kosher slaughter is a problem that's endemic to self-regulation in industry. And finally, there were attempts at government regulation. The problem was inadequate resources. The 6 full-time kosher inspectors in the New York City Department of Markets and the 10 in the New York State Kosher Enforcement Bureau, which is not a small amount of staff for state or city regulation, by the late 1930s were insufficient to oversee the 18,000 kosher food establishments in New York City. So let me just summarize briefly the failure of communal control over kosher meat production according to this old Kehillah model. Religious voluntarism and free markets undermine communal control over kosher meat production in America. And the synagogue community in America lacked the exclusive jurisdiction and monopoly power that the old world Kehillah had and used as the primary means of kosher meat regulation. Now, ironically, the very features of the American liberal state that attracted all of these Jewish immigrants, 1.4 million to New York City, that is religious freedom and economic opportunity, were the very factors that undermined their ability to exercise communal forms of religious governance. So they came to America precisely for these features of liberalism, and it was precisely these features of the liberal state that undermined their ability for legal autonomy. Reform finally came to the American kosher food industry with the rise of a new regulatory institution in the Jewish community that was better suited to the American context, and that's the private business enterprise operating in a competitive market. I want to turn now to what I call private regulation, the modern American kosher certification system that replaced the Kehillah model of kosher certification and regulation. The Industrial Revolution, in many areas, but especially in food, gave rise to an increasing volume and variety of processed and prepared foods that were sold in a nationwide mass market throughout the country. And this took place at the same time as the rest of the Industrial Revolution in the late 1800s and early 1900s. Jewish consumers created the demand for kosher certification of these industrially processed and prepared foods. Now, when industrially prepared food obtains certification, it goes through the following process, which I'll summarize briefly. There's an initial inspection of the production facility and its equipment to make sure that none of the production equipment violates any of the standards of kosher law, and that the ingredients coming into the facility are also in accordance with kosher regulations. There's a contract, a private contract signed between the certifier and the food company, which specifies standards for ingredients and equipment and production, and allows for unfettered and unannounced inspection of production facilities, all of which is being done on a private contractual basis. There's periodic monitoring that's set up, which involves different levels of scrutiny depending on the type of production and the company involved, and that may be weekly inspection or a monthly inspection or biannual inspection. And fees for this service range from $2,000 to $100,000 per year. This is a money-making job for certifiers. Now, this new version of industrial kosher certification that was different than the meat model involved a change in the economics and the business model of kosher certification in the following respects. First of all, kosher certifiers went out and they sold to the American food industry, the industrial food industry, kosher certification as a marketing device. And here's how they did it. Kosher certifiers went around the country to Procter & Gamble or Duncan Hines, and they went to Duncan Hines and they said, I can increase your sales of cake mix. Here's how we're going to do it. Duncan Hines says, how can you do that? There are not enough Jews who are buying cake mix to make a difference. And the kosher certifiers said, the name of the game in food, packaged food marketing is shelf space. If you walk into the supermarket and you don't know what cake mix to buy, you're going to walk into the cake mix aisle, and dollars to donuts, you're more likely to buy a cake mix that's in the middle of the shelf at 5'5" than you are to buy one that's at the bottom of the shelf. So the kosher certifier said, we can guarantee you better shelf space in key urban markets around the country. We're going to put kosher certification on Duncan Hines cake mix. And in Brooklyn, North Chicago, Atlanta, LA, Miami, and Baltimore, you're going to see a dramatic rise in sales among kosher consumers. And lo and behold, they did. And in each of those markets, they moved Duncan Hines cake mix because of the bumps in sales to the middle of the shelf. And when that happened, non-kosher consumers saw the product and they bought it. And when that happened, supermarkets around the country provided better shelf space for Duncan Hines. They saw within 6 months a 40% jump in sales. This idea caught on like wildfire. It took about 20 years in the making, but the idea was that if you bring a new packaged food to market, you can get better shelf space with kosher certification. And once this happened, and it was a great deal, by the way, because unlike meat certification, which requires trained ritual slaughter and constant supervision of the meat from the time of slaughter to the time of sale, you're just talking about an initial inspection and someone coming every 6 months or every 3 months to come check the factory. You could spread that small cost over 10,000 or 100,000 production units, boxes of cake mix. You don't even have to mark up the product because the extra sales will more than swallow the cost of certification. This became a great marketing tool for kosher certification, and so the question becomes, why should a company buy my certification and not your certification? I mean, after all, it's kosher certification is kosher certification. So we get the entry of competition among certifiers in terms of brand competition. Certifiers have to brand differentiate. They have to distinguish why it is that my certification is better than yours. And brand competition in kosher certification is based on what they're selling, which is reliability. The only real product in certification is reliability. You're selling your reputation for reliability among kosher consumers. And the two ways to compete in terms of brand for reliability that were undertaken were building the integrity or the reputation for integrity of the certifier and building expertise. The first thing they did in integrity is they actually backed their claims of integrity with actual structural reforms within the organization. So they built in extra levels of management oversight, and these agencies created a whole new cadre of middle managers. And in addition, they separated out kosher standard setting, which was done by rabbis, from business development and business decisions, which was done by administrators. And these are things that, of course, are extremely common within administrative law and also private regulation in other areas. These are standard moves for administrative and bureaucratic administration. And so the kosher certifiers were riding this cultural wave of creating integrity and selling that because that was their real product. In addition, they developed expertise. They started professional training in Jewish law. No longer was it good enough just to have a local rabbi come over and check out the factory. They actually provided people specific training in Jewish law, food technology, food processing, and customer relations. And they also created specializations. So if you go to one of these certifiers today, there's a guy whose sole job, he's been working at this for 15 years, is to look at glycerin and the use of glycerin in industrial food production and its implications for kosher food certification. And there's another guy for emulsifiers. There's a high level of specialization. So each of these certifiers was able to back their claims of brand reliability with greater integrity and expertise. Today, the landscape is as follows. There are about 300 certifiers in the United States, independent certification agencies, and these are dominated by 5, known as the Big 5 in the business. The OU, the OK, the StarK, the CUFK, and the CRC, they certify about 80% of the hundreds of thousands of kosher food ingredients and retail products on the US market. Now, the Big 5 agencies not only dominate the kosher certification market, they also develop and enforce industry standards. They self-regulate. Industry standards sometimes referred to as the American standard of kosher certification. And this standard determines which agencies are considered reliable and which are not. This is the regulatory system in action. The kosher certification industry's enforcement of industry standards relies on a number of structural features of the industry. And these are largely either market structures or the sociological or social context within those market structures, within which those market structures operate. First of all, there's brand competition, as we've mentioned. Competition for clients provides agencies incentive to uncover and publicize lax practices by other agencies. Each agency is looking for a way to increase their market share in the certification market, and they are hungry for any information that might impugn the reliability of another agency. And as a result, there's an intense self-policing that's going on within the system of agencies. Second, agency interdependence. The structure of industrial food supply chains means that misdeeds by an agency certifying ingredients can damage the reputation of agencies relying on the kosher status of those ingredients further downstream in the production process. If you are a certifier and you certify cake mix, you need to make sure that the flour and the flavorings and the chocolate and whatever else is going into the cake mix are properly kosher certified. And if the people certifying those ingredients screw up, then the kosher certification of that finished product is impugned and you take a hit. So everybody who certifies a finished product is very busy making sure that the people certifying the suppliers of that product are doing a good job. And because each certification agency serves both in the food chain, depending on the product, as the finished product certifier and as the ingredient certifier, there's a web or an interlocking system of scrutiny of each agency over each other. Third, customer vigilance. There's a core of active consumers that are motivated by personal religious commitment to uncover problems and report them to agencies. I'll take a little bit of liberty here and tell you my favorite story about consumer vigilance. There's a story that Rabbi Luban, who's a deputy at the Orthodox Union, which is the largest certifier in the United States, tells, that they had an account with an industrial food manufacturer who made cookies and cream ice cream. And they made cookies and cream ice cream that had kosher certification. It was very popular. Now, the ice cream company came to the OU and they said, we would like to take an opportunity to just come our way. We've been asked to make cookies and cream ice cream with Oreos, real Oreos. And of course, this was back in the 1990s, and Oreo cookies were not kosher. And this was widely known because most kosher consumers wanted Oreo cookies, and they couldn't have them. They had cheap imitations. So the OU said, look, we'll allow you to do this, but only in the following circumstances. You have to separate out the kosher cookies and cream production from the Oreo cookies and cream production. The Oreo cookies and cream production, the Oreo cookies had lard in them back then. So the company agreed, and they went ahead with production. 4 weeks later, Rabbi Lubin gets a call from a little lady in North Jersey. She says, Rabbi Lubin, I was eating my cookies and cream kosher ice cream, and I eat my cookies and cream ice cream every evening after dinner. I noticed there looks like what appears to be Oreos in the ice cream. And I thought Oreos aren't kosher. Do you guys certify Oreos? So Rabbi Lubin said, I'll look into it. So he got off the phone, and he went down to the factory, which was also in North Jersey. And he walked to the factory floor and announced, he said, I want 10 gallons of cookies and cream ice cream. And they gave it to him. And he took the 10 gallons back, and he put them in the sink, and he took the top off, and he poured hot water on them. And he melted all the ice cream off. Sure enough, there were Oreos. And he went back to the company and said, how could you do this? We had an agreement. And the owner of the company said, we got a contract to do this, and we bought $25,000 worth of Oreos with a short expiration date. And then they backed out on the contract. They said they didn't want cookies and cream ice cream. We had to do something with all the Oreos. So we put them in production. So it's a great example of how it is that it's not just the agencies that are out looking for things. There are kosher consumers everywhere because of the nature of their commitment to kosher observance who are acting as eyes and ears for all of these agencies, and that radically expands their regulatory monitoring reach. Concentration of market power. The concentration of market power in the hands of a few agencies, the Big Five, makes it easier to coordinate the development and enforcement of industry standards. It would be very difficult from a coordination point of view to put together standards with 300 different certifiers, especially when they involve rabbis. But here we're talking about 5 large ones that are trendsetters, and that helps ease coordination. So the key features of the kosher certification system that make it work, this private entrepreneurial system, are consumer demand, grand competition, a high degree of interdependence, consumer vigilance, and the concentration of market power in the hands of a small number of certifiers. Now, there's also a government system of kosher regulation, but the government system of kosher regulation today is extremely weak. 22 states have kosher fraud laws. However, the officials charged with enforcing the laws are often unaware of them or lack basic knowledge about kosher certification. My research assistant called the Chief of Consumer Affairs at the Arkansas Department of Consumer Affairs in the Arkansas Attorney General's office and said, I'm calling you about your kosher fraud law. He said, well, we don't have a kosher fraud law. The state of Arkansas doesn't do that. So my research assistant said, well, it's in front of me on Lexis. And the head of the Consumer Affairs Division in the Attorney General's office in Arkansas said, oh, really? And he looked it up and he said, wow, I didn't know we did that. You should call the health department. They may have something to do with this. And he was met at the health department with similar surprise. So there are kosher fraud laws out there, but they're not really on the agenda of most state regulators. Most enforcement, where it occurs at all, is purely reactive to consumer complaints. The state does not conduct routine inspections like the private system does. And even in the 2 states with routine inspection, New York and New Jersey, kosher fraud enforcement has been limited by budget cuts. So New York has been decimated. New York used to have 10 full-time kosher inspectors. The state of New York now has 1. And they folded kosher inspection into general food safety inspection with a bunch of people who don't know anything about kosher. Existing evidence suggests that the kosher system works very well, this private system, and that fraud is extremely rare. Agencies' consumer alerts and internal records indicate a low incidence of adulteration and misbranding of kosher food. For example, the Orthodox Union reports that among the 500,000 products that the agency certifies, the agency investigates about 500 cases of questionable use of the OU symbol each year and takes corrective action only in about 50. And furthermore, these statistics from the agencies themselves are backed by available data from state regulators. New York State kosher law enforcement records reflect that between 2005 and 2010, 5-year period, the agency conducted more than 3,700 inspections of nearly 900 industrial kosher food production facilities, but they found only 4 violations of the kosher fraud law and issued only 16 warnings. That's an extremely high rate of regulatory success when you compare that to other systems of food regulation. So in conclusion, I just want to reiterate the thesis that the same aspects of the liberal state, religious liberty, and free markets that account for the failure of communal regulation of kosher certification also account for the success of private certification and regulated kosher certification. And if religious regulation, and this is a sort of more speculative implication, if religious regulation can adopt institutional forms that are compatible with the liberal state, such as religious voluntarism and market competition, the liberal state can support effective instruments for religious regulation and legal autonomy among religious communities.
Thank you very much, Tim. And one thought before we go to our next presenter. So since Tim was talking about fraud, it made me realize that I should probably fess up. If you notice, Tim is not on our program here, and in fact, neither is the second speaker on today's program. We had some problematic, unfortunate, good faith cancellations at the very last minute, and we have these 2 wonderful speakers who are stepping in. So thank you very much, Tim, for that presentation, and that was Tim. I just want you to know, okay. And our second presenter is actually going to be on a panel tomorrow as well. So she's doing double duty. Her name is Lena Salaymeh, and she is a Robbins Post-Doctoral Fellow at the University of Chicago Berkeley School of Law. She has a PhD in Legal and Middle Eastern History from UC Berkeley, and she has a JD from Harvard Law School. She has publications, Early Islamic Legal Historical Precedents, Prisoners of War, and she's made contributions to books as well. Thank you very much for agreeing to speak on our first panel. And Lena.
Thank you. We have 20 minutes or half an hour?
20 minutes or half an hour.
So I have a tendency to read quickly, or talk too quickly. So if I'm going too fast, please signal to me. So what I'm going to present today is actually a small slice from an article that I'm publishing this year with the UC Irvine Law Review, this symposium issue. It's titled "Every Law Tells a Story: Orthodox Divorce in Jewish and Islamic Legal Histories." So the piece is primarily historical, but I want to begin by explaining the relationship between the historical narrative that I'm going to tell you and the contemporary situation. So the question that I want you to be thinking about is what happens when the adherent of a religion abides by a legal system that is in some way in conflict with a secular state. So sometimes the state issues an intervention. So for example, in the 1983 case, Arbitration versus Arbitration, the New York Supreme Court ordered a husband to appear before the rabbinic court to divorce his Orthodox Jewish wife. And this case led to New York Domestic Relations Law, Section 253, which requires parties to a civil divorce to remove all barriers to remarriage, presumably, including by meeting rabbinic divorce requirements. So in other words, this law seeks to use the authority of the state to force Orthodox Jewish husbands to deliver divorce decrees, gets, to their wives in order to finalize a civil divorce. But this civil legal strategy does not entirely resolve the issue of so-called chained wives for Orthodox Jewish communities. I'm very conscious of having Rabbi Boyd in the room since he's written about this. And I'm sure he can tell us more from an internal perspective what this is about. But so the reason why I bring this up is simply that I'm going to consider a historical context in which there's a similar sort of intersection of a sense of pressure to conform to state practices and the assumption that one's religious practices are fundamentally distinct from those state practices. So that's sort of the overall idea I hope that you'll have in mind, is this idea of a state practice and a religious tradition as somehow being opposed to each other, and whether it's really the case. So the received tradition narrates a woman's minimal agency in divorce in both Jewish and Islamic law as intrinsic. And it's widely known or presumed that Jewish and Muslim women have relatively less access to divorce than their male counterparts in present-day religious courts. So in both religious traditions, women can encounter difficulties in obtaining divorces. So this situation, however, simplifies a complicated historical process, and only part of which I'm going to briefly explore here, in which a woman's access to divorce changed over time. So I'm going to be trying to summarize like 1,000 years of Jewish legal history in like 5 minutes. And I'm partly going to do some of, you can tune out if you don't want to hear it. But because there's people in here who are familiar with these names and these ideas, I'm going to say them, but you'll get the point eventually, so don't be overwhelmed. Okay, so rabbinic jurisprudence on divorce is ostensibly built around one biblical verse, Deuteronomy 24, verse 1, which describes a husband delivering a divorce document to his wife. And so this is the verse that ostensibly makes it impossible for a woman to effect a divorce herself, because she presumably must wait for her husband to give her a divorce document. Now, the Babylonian Talmud, however, also discusses the situation of a recalcitrant wife who loses her dower for refusing to obey her husband and is divorced after a 12-month waiting period. You don't have to read the whole thing. I just put it up there for those who want to read it. And I'm going to move quickly, so I apologize. Now, in 650 or 651 of the Common Era, Gaonic rabbis, and Gaonim are the rabbinic figures who lived under the Islamic Empire, basically. So they issued a decree, a takana, that a recalcitrant wife, a morevet, could procure a divorce immediately and not lose her dower, her ketubah. So this decree abandoned the 12-month waiting period and loss of dower that was stipulated for a recalcitrant wife in the Babylonian Talmud, reading in these verses. Now, historical sources indicate that this decree was viewed by the majority of Gaonim as a legal enactment validated by judicial authority and social need. And Geniza evidence indicates that in the medieval Near East, Jewish women could initiate divorce by forfeiting some of their rights, what is often described as a ransom divorce, in line with the equivalent Arabic terminology. So this historical evidence needs to be emphasized. The Gaonic practice of coercing a husband to divorce a recalcitrant wife was normative for centuries until its gradual undermining in the late medieval period. And this form of wife-initiated divorce appears to have been implemented by the Gaonim as an extension of the Talmudic category of a recalcitrant wife. So the verses, the passages from the Talmud that I just showed. And it was accepted by figures like Rabbi Yehuda ben Nachman, who died in the late 8th century in Iraq, and Rabbi Isaac al-Fasi, who died in the 12th century in Spain and Algeria. So a woman's ability to initiate a divorce without citing one of the grounds specified in the Babylonian Talmud, however, became, during the period of the Rishonim, an issue debated by jurists with a variety of regional practices. So I have like several pages of sources, but I didn't want to give you all these sources, so I'm just giving you some of them. This is another Gaonic source that talks about the recalcitrant wife. I didn't actually put up any other ones, sorry. Okay. So, the Rishonim debated a rabbinic court's ability to coerce a husband to divorce his recalcitrant wife by making conflicting assertions about the so-called origin of the law, the Talmud or the Gaonic decree. So Rashi, for example, suggested that the Talmud was the source of the practice. In comparison, Maimonides criticized but did not entirely reject Gaonic practices pertaining to a wife's ability to demand a divorce as a recalcitrant wife, which he viewed as being based on Talmudic practice. So a practical application of his legal opinions, the Rambam's legal opinions, is evident in a Maimonidean response which makes clear that a woman who chooses to divorce leaves without her dower, and the husband is forced to divorce her. So this debate among the Rishonim about the legitimacy of the Gaonic decree was fundamentally related to broader questions of the authority of jurists. Rashba accepted, for example, Rabban Tam's opinion that the Gaonic practice was not based on the Talmud, but he did not describe it as legally valid. Rabbeinu Asher of 14th century Spain opposed the Gaonic decrees on the grounds that it was not accepted by a majority of Jews and that social circumstances had changed since its enactment. The point being that by the early 14th century, a perspective of the Western Rishonim that the Gaonic decree was invalid began to take hold. So by the 16th century, a major Jewish law code acknowledged a rabbinic court's ability to compel a divorce, but only in situations of a husband's unwillingness to support his wife. So the point that I want to make more broadly, and this is where I'm not going to get into details, but the legal practices of the East, including Babylonia and North Africa, can be differentiated from the legal practices of the West, which is primarily Europe. So Jewish communities in the East continue to coerce husbands to divorce their wives, as documented by Geniza evidence. The perspective of Western rabbinic authorities appears to have arrived in the East at the end of the 14th century, when two rabbinic jurists, Raibash and Rashbaz, moved from Spain to North Africa and prohibited coercion of a husband to divorce a recalcitrant wife. So the question I want to explore today is why this specific Gaonic decree has been interpreted, both by late medieval rabbinic authorities and by contemporary scholars, as having deviated from Talmudic practice. A late medieval rabbinic consensus gradually developed in the West that viewed the Gaonic decree as an innovation caused by the influence of Gentile courts, Islamic courts. And contemporary scholars have presumed that the Gentile courts were Islamic and thereby characterized the Gaonic decree as being caused by Islamic pressure of some kind. So these two characterizations of innovation and influence must be reevaluated because they obscure a complicated historical struggle for legal authority. And what I'm going to do for the rest of the presentation is just provide some historical or critical evidence to offer an alternative understanding of this Jewish law and its Islamic context. And hopefully you'll see kind of the echoes of that in a contemporary situation. So at the time of the Gaonic decree in the mid-7th century, a minority of the population was Muslim, and Islamic courts were not adjudicating outside the garrison towns established during the Arab Muslim conquests. So that a minority Muslim presence could have such significant effect on Jewish legal practice as to provoke the enactment of a decree within decades of the beginning of Iraq's conquest is actually historically improbable. In other words, the orthodox assumption that the Gaonim deviated from Talmudic practice in order to defend against the threat of Muslim influence, coercive or otherwise, is based on inaccurate historical evidence. The majority population at the time in Iraq was actually Christian or Zoroastrian. Among Eastern Christians and Zoroastrians, women returning their dowers to effect a divorce is a historically verified practice. So since even after the Muslim conquest, local communities operated courts, the Gentile courts, meaning Islamic courts, or other courts that provoked the Gaonic decree may not have even been Islamic. So wife-initiated divorce may not have been the dominant Islamic legal practice because it was the subject of intense juristic debate among Muslims, and possibly only one of many legal positions. In the article, I go into the details about all the different Islamic legal opinions, but you can just take my word for it. It's not actually clear that a wife-initiated divorce was prevalent in the 7th century. So the Orthodox Jewish narrative inaccurately assumes the existence of Islamic influence that's actually negated by the historical evidence. So more probable than the existence of or prevalence of Islamic courts is the possibility that Jewish women simply knew that Muslim women or other women, Christian or Zoroastrian women, who demanded divorces did not have to wait 1 year, the 12-month waiting period specified in the Babylonian Talmud, in addition to having relatively more expansive inheritance and property rights. So threatened by the possibility of Jewish women converting, Gaonic rabbis likely reduced the waiting period. Now, this practical modification could be understood as reacting to an internal social demand, not necessarily influence. And in legal terminology, we can identify this kind of legal change as a social welfare or public interest, and it's endemic to all legal systems. So while Jewish women in the Near East and North Africa were able to acquire divorces in rabbinic courts under a recalcitrant wife claim throughout the medieval period, they apparently still frequented Islamic state courts. So since even in places where rabbinic courts facilitated wife-initiated divorce, Jewish women availed themselves of those state courts, the Gaonic enactment didn't actually prevent Jewish women from accessing other legal options. So to appreciate the dynamics of legal pluralism, we need to recognize such complexities as venue shopping and socioeconomic barriers to legal consumerism. So the influence theory that I'm critiquing does not sufficiently explain how the Gaonic enactment actually protected the Jewish community from two realities: the availability of the state courts, the Islamic courts, that facilitated a Jewish wife's divorce, and the possibility of conversion. So the Orthodox narrative claims that Jewish women who had to wait 12 months for a divorce fell into indecency, illicit affairs, or apostatized, presumably becoming member of another religious group. Ostensibly, the Gayonim dispensed with a long waiting period in order to hasten a Jewish woman's divorce and prevent her apostasy for the purpose of divorcing her Jewish husband. Yet a Jewish woman who became Muslim would not necessarily have been automatically divorced because this very Islamic doctrine was not clearly established in the mid-7th century. So while now a majority of Muslim jurists would claim that someone who becomes Muslim after a woman who becomes Muslim basically, automatically divorces her husband, the traditions from the late antique period are actually quite conflicting. And it's entirely possible that in the 7th century, a woman who became Muslim did not necessarily automatically divorce her non-Muslim husband. So how could the Gaonic rabbis have compelled a husband to deliver a divorce decree instantaneously when husbands very often delayed the process? If the Gaonic practice removed the 12-month waiting period and then relied on coercing the husband to grant a wife a divorce, then the threat of conversion to Islam remained. That is, a Jewish woman might simply become Muslim and demand a judicial divorce decree from an Islamic court rather than wait for her husband to deliver her divorce decree under coercion. So it's no coincidence then that the Karaites did accept judicial divorce decrees and that Maimonides denounced the practice as heretical. The specific wording of several Gaonic texts implies that courts granted or gave Jewish women divorce decrees without explicitly delineating that the courts coerced husbands to deliver those divorce decrees. So while we cannot make conclusions based on this precise terminology, it is likely that judicial divorce decrees became a site of Orthodox Jewish contestation in the medieval period. It was not only Muslim influence that concerned the rabbis, but the sectarian influence of Karaites. Western rabbinic jurists may have marked the boundaries of rabbinic orthodoxy against Karaite heresy through this particular legal issue. And the extent to which generalizations may be made from this case study to broader processes of sectarian resistance and regional competition in the shaping of rabbinic Jewish orthodoxy is a matter for further research. So most Gayonim did not view their practice of facilitating wife-initiated divorce as divergent from Talmudic traditions. The Gaonic enactment included two aspects. The first was the removal of the 12-month waiting period stipulated in the Babylonian Talmud for the recalcitrant wife, and the second was coercion of the husband to grant a recalcitrant wife a divorce. The Gayonim actually perceived the first aspect as new, that is, the removal of the 12-month waiting period, but not the second aspect, coercing a husband to divorce his wife. So later rabbinic authorities interpreted both aspects of the decree as innovative, despite the Gaonic perspective that they had preserved rabbinic Jewish tradition. So the Orthodox narrative thereby marks as heretical the prolonged practice of Gaonic communities who facilitated wife-initiated divorce. So what underlies the characterization of the Gaonic decree as an innovation is the causal presumption of influence. It's commonly assumed that the availability of divorce for women in contemporaneous Islamic courts led Gaonic rabbis to modify divorce practices. But Gaonic texts do not explicitly identify Islamic courts as being a causal influence on the decree. So for example, Natronai ben Hillel, Gaon, who died in 9th century Iraq, explained the rationale for the decree as, quote, so that Jewish women should not stray towards lewdness and indecency, end quote. Some Gaonic sources do not mention a reason for the enactment. Now, of course, these Gaonim may have been influenced by Islamic legal practices and simply did not admit it. But in analyzing this historical event, we should focus on the consistency and plausibility of the historical interpretations. And in light of the aforementioned historical evidence, specifically from the Geniza evidence, early Gaonim did not cite Islamic influence for the decree because no such influence existed in their time. And again, here the parallel with the state courts would be to think about how state pressure actually influences how people view the history or view a change in the legal system. So Shari'a ben Halakha, who died in the 11th century in Iraq, writing in the late 10th century, identifies the decree as being an attempt to prevent Jewish women from asking Gentile courts to coerce their husbands because only a Jewish court can legitimately coerce a Jewish husband to divorce his wife. But in his lifetime, Islamic courts were prevalent, and when petitioned by Jewish wives, they probably did coerce Jewish husbands to deliver divorce decrees, or probably granted divorce decrees to Jewish wives. But Shari'a Gaon may have anachronistically interpreted the reasons for the 7th century Gaonic decree based on his own reality in the 11th century, that is, or the 10th and 11th century. That is, since Shari'a was surrounded by Islamic courts, he may have simply assumed that his Gaonic predecessors were likewise competing with Muslim jurists for Jewish litigants. But Shari'a Gaon is actually the only known Gaonic figure to attribute the influence of Gentile courts to the Gaonic decree. So what's problematic about influence as a characterization for a particular historical event? Influence is really code for infiltration or for impurity. The Orthodox understanding of the Geonic decree focuses on the causal factors rather than the context that led to its enactment and presents the decree's gradual overturning as if it had occurred in the absence of causal factors. So it validates a specific bias that can be identified in terms of time, the medieval era, and space, the West, because it was Western Rishonim who characterized the Geonic decree as unorthodox. And what's notable about the Orthodox narrative is that Western Christian influences are unacknowledged or minimized while Islamic influences are vilified, and both legal systems are dramatically oversimplified. The distinctions between Christian teachings on divorce may reflect discrete regional practices. So while it's not surprising that Western Rishonim did not describe their annulling of the Geonic decree as being the result of Western influence, it's remarkable that contemporary scholars perpetuate this selective application of the notion of influence. I'm just going to give you an example of one. Westwright noted that the process of erosion of the recalcitrant wife divorce moved along the lines of advance of Christian society, which gradually conquered and dominated areas that had so far been under Muslim influence and control, at least in Spain. And Westwright explicitly observed that Rabbeinu Tam's legal opinion against the recalcitrant wife divorce occurred, quote, as Christian society became monogamous and imposed Catholic laws making divorce impossible, end quote. So contemporary scholars pose a question about the influence that provoked the Geonic decree, but not about the influences that led to the overturning of that decree. So to be clear, though, I'm not arguing for Western Christian influence on the Western Rishonim. To do so would replace one problematic influence paradigm with another. Instead, I contend that all legal communities are constituted by their context, and those include state structures. Just as the Geonim read the Talmud through the intellectual concerns and socio-political realities of their times, so too did the Western Rishonim. And these two historical moments, the enactment of the Geonic decree and its abolition by Western Rishonim, are both reflective of and mediated by jurists enmeshed in their societies and entangled in their state structures. Late medieval Western jurists marked the 7th century Geonic decree as an innovation caused by Gentile influence within a struggle for legal authority. The Geonic decree was marked as deviant not because it occurred under Gentile influence, but because its revocation occurred in a Western Christian context. So contemporary scholars delineated the other by placing a Jewish law in an imagined Islamic context instead of a historical one. They imagined all sorts of things about the Islamic state and Islamic legal practices that are actually not historically verifiable. Both some Western Rishonim and some contemporary scholars employ a notion of influence that manifests reductive causality and thereby is an impediment to deeper and more complex understanding of historical change. So I've illustrated, or tried to illustrate, the importance of considering the ways in which jurists define the other by placing a Jewish law in this imagined rather than historical context. And what this case study demonstrates is that the characterization of the 7th century Geonic decree as an innovation caused by Islamic influence was part of a normative strategy embedded within a struggle for legal authority. The Geonic decree was marked as deviant not because it occurred under Islamic influence, but because of its revocation in a Catholic context. Okay, so how is this relevant to modern nation states? I think I'm running out of time. The fear, So the fear of state influence acts as a hindrance to change in Jewish and Islamic legal systems in the contemporary world. Every legal system has built-in mechanisms for adapting to changing social situations or responding to crises. But if those situations are understood as pressure from the state, then the legal system is sometimes resistant to change. And we can see evidence of that in the way that certain legal changes are understood by the communities as being caused by the pressure from the state structure rather than necessarily being caused by internal needs or internal issues. And I hope we can discuss more of the connections in the Q&A. Thank you.
Well, thank you very much. And our third speaker is Michael Helfand, who is an associate professor at Pepperdine University School of Law and associate director of the Glazer Institute for Jewish Studies at that institution. He has his JD and a PhD in political science from Yale, and his research interests are in law and religion, arbitration, and constitutional law. And actually, just a quick thought as a connection. I think that the first two papers have looked at internal responses largely of the community itself perhaps to external pressures, but to problems that they're presented with And I think somewhat by contrast, Michael is going to be looking at the way that a secular state can facilitate the religious community solving problems within it.
Thank you very much for having me here, the conference organizers. Very excited for the next 2 days and to talk a little bit about religious law. Given the topic of the conference, I thought I'd talk a little bit about the way in which the United States legal system views religious law. And I have 2 goals in mind here. My first is to try to show you the way in which, at least in some contexts, there's an inherent struggle or conflict or tension in the way in which U.S. law views religious law. At times like law, at times like religion, somewhat of a hybrid concept. And I'd like to advocate as a second goal of the talk this morning, ever so slightly maybe, in favor of what I refer to as demystifying religious law. And by that I mean to start to move our conceptualization of religious law a little bit away from religion and a little bit towards law. Think about it less like religion and more like law for reasons that I hope to express towards the end of this morning's talk. To do this, I have to do something unfortunate, which is to talk about U.S. arbitration doctrine. So I'm going to try and run through that a little bit. Hopefully all of you are brushed up on your on arbitration and recent changes on the Supreme Court. But let me just say a little bit for the beginner. Arbitration is a pretty simple concept, something that we do pretty frequently. For all of you with iPhones, you've done it. Or any other Apple product. All it is you and I, 2 people, agree, instead of going to court if you have a dispute, we sign an agreement, and all the agreement says is we're going to pick some third-party neutral who's going to resolve the dispute. What's kind of amazing about arbitration is once 2 parties voluntarily agree to submit a dispute to arbitrators as opposed to court, that award issued by arbitrators can be enforced by a court, or what's called typically in most jurisdictions, the award can be confirmed. And once that award is confirmed, it has the power of a judgment like any other decision of a court of law. You can do all good fun things with the confirmed arbitration award. You can levy bank accounts, you can take liens on property, garnish wages, all the things we enjoy doing with judgments. Over the past 30 years, increasingly, the U.S. Supreme Court has taken a very pro-arbitration stance, expanded it again and again, its enforceability, to the point where people begin to wonder if there's going to be anything left to the world besides arbitration. Now this is all nice and well and good and fascinating to probably very few of you, but the more interesting piece of it is the way in which this has kind of galvanized religious arbitration in the United States. Primarily Jewish and Muslim communities, although also Christian communities, have taken advantage of this pro-arbitration environment by increasingly looking to religious arbitration tribunals to resolve their disputes. And when I say religious arbitration tribunals, I mean something very simple. Nowadays, 2 parties, 2 members of any given religious community can sign a religious arbitration agreement, which is typified by 2 provisions. First, there's an arbitration provision in this document that says we select particular religious authorities to resolve our dispute. And we also incorporate into this agreement the choice of law provision, which specifies a particular brand of religious law that we would like the arbitrators to use to resolve our dispute. And so by doing that, we have a religious arbitration agreement that allows religious authorities to resolve our dispute in accordance with selected religious law. Now, this religious law works in 2 important ways. The first is, as is relevant to the substantive merits of the dispute. So whatever our dispute is, a contract dispute, a tort dispute, think of anything fun you've had recently. What it does is the substantive merits of the dispute are resolved under religious law. We look to religious law in order to figure out what the answer to the dispute is. But another important piece of the puzzle is the procedure. The process by which the arbitrators resolve the dispute is also governed by religious law. Issues like notice and evidence and all the other things that come along with an arbitration are governed by the relevant religious legal rules. All of this packaged together means that what religious communities have been able to do is take advantage of this kind of pro-arbitration environment, this hospitality to and encouragement of arbitration to support the decisions of religious tribunals and enable members of religious communities to resolve their disputes in accordance with religious law. Now, this entire regime is not without constitutional critics. To some, this whole notion that we have religious arbitration out there that can be confirmed and enforced in court, that can take religious law and end up using that in the end, trickle down to levy your bank account, is something that some critics say seemed unseemly, maybe constitutionally unseemly. Maybe it's the case that courts should not be involved in the process of enforcing religious legal decisions. But no court in the United States has ever held that there's some sort of First Amendment problem in having courts enforce or confirm religious arbitration awards. And the reason is actually relatively straightforward, and it comes from arbitration doctrine. Generally, under arbitration, courts are not allowed to revisit the merits of the decision by an arbitrator. To do so would undermine its enforceability and predictability and make arbitration a farce. And so, when you bring an award to court, and you ask that court to confirm the award, the arbitrators are hands off. They don't investigate whether or not the award was correctly decided. They check if there are arbitration agreements. They check what the award requires, and then they confirm it. They never have to revisit the religious underpinning of the decision, so they avoid all the First Amendment entanglement problems that many of you are familiar with. The problem, though, and here's what I'd like to discuss primarily today, is while the substantive merits are beyond the ken of courts, so to speak, the procedural problems are not. Courts still, as it applies generally to arbitration, need to review the arbitration procedures used by any arbitrator for compliance with various statutory provisions, generally aimed at ferreting out certain forms of procedural misconduct. Let me give you some fun examples. Corruption or fraud used to procure an arbitration award can undermine the enforceability of the award if there's evident partiality of the arbitrators, if the arbitrators fail to admit quote-unquote pertinent and material evidence, if they fail to provide notice of hearing, or if they generally exceed the powers granted to them under the arbitration agreement. All of these are things that a court needs to look at before it confirms the award. It needs to make sure that the process by which the arbitration award was issued complied with statutory requirements. Now, this latter issue, the kind of procedural challenges to religious arbitration awards, can cause a variety of problems and has actually come up with increasing regularity in the United States. I think the most well-known decision is in 2011, a Florida court said it was going to review the procedures of an Islamic arbitration tribunal for compliance with quote-unquote ecclesiastical Islamic law. Now, this made a lot of good sense. This is actually what the agreement between the parties required. The parties submitted a dispute for Islamic arbitration. And as a result, based on the agreement, the arbitration had to comply with Islamic procedural law. And this was just a matter of contract. Unfortunately, the press in Florida, not quite skilled in the nuances of arbitration doctrine, pitched this in a little bit of a different way. And so you got newspaper articles that one title was, quote, "Judge orders use of Sharia in suit." Another ones emphasized how Florida judge had, quote, decided to apply Islamic law instead of state or federal statutes. And then Florida all of a sudden became the center of the national anti-Sharia movement in ways that were bizarre, disturbing, and unfortunate. And of course, this could have all been solved if we had just talked about arbitration doctrine. But in any event, and courts kind of, you can see, the judge in the case actually issued a supplemental decision trying to explain that this was simply a matter of contract doctrine. But again, the problem inherent in it was the need if you have a procedural challenge to arbitration, it draws you into investigating issues of religious law in a way that the substantive merits of arbitration doctrine typically prevent courts from doing. This hasn't just happened in the context of arbitration. This is a recurring problem in some of the Church of Scientology litigation. If any of you have ever read a Church of Scientology arbitration agreement, you may know that it requires any dispute between the Church of Scientology and any of its members or people trying to become former members to be resolved by 3 members of the Church of Scientology, quote, in good standing. The allegation, of course, is that if you find against the Church of Scientology, you're no longer in good standing, and therefore it wasn't arbitrated. This is kind of the cyclical problem that some people have noted, and complicated all on its own. But one of the issues, again, is the way in which courts are meant to police religious arbitration for procedural problems. And in a way, in each occasion, it draws the court into questions of religious law. And that's what I'd like to talk a little bit more about today, talk a little bit about these procedural challenges and how they're a kind of a proxy for seeing this hybridity of religious law. Again, the key problem here comes from something known as the religious question doctrine. Religious question doctrine generally prohibits courts from investigating matters of church doctrine or practice. So anytime a dispute requires the resolution of a religious question, courts are told that this is beyond their jurisdiction. They lack the competence and authority under the First Amendment to resolve this type of dispute. And this doctrine looms large when we're talking about procedural challenges. When a court is asked to determine whether or not procedural requirements, statutory procedural requirement has been resolved by arbitrators, courts invariably are drawn into questions of religious doctrine in two ways. The first is they're typically asked to interpret questions like requirements of notice, materiality of evidence, and the like through the prism of religious law and doctrines. What is material? How much is adequate notice is typically governed by religious rules, and so courts are immediately drawn into questions of religious doctrine in the context of procedural challenges in that way. And also, invariably, such challenges have a second component, not just what is a defining deterrence, but also whether or not the right rules were applied. How do you know whether the right rules are applied by a religious arbitration tribunal without determining first what the religious rules are? And of course, as soon as courts are asked to do that, they're immediately drawn into a First Amendment problem. In such instances, courts find themselves handcuffed, disabled from using their standard interpretive and fact-finding powers to resolve the claims that are being presented. Okay, so I'd like to look at these procedural challenges. I'd like to take a case study and just work through basically a hypothetical. As we say in law school, let's work through a hypothetical case and see how it'll come out. And I'd like to show you the way in which these procedural challenges lead to this kind of hybrid conceptualization of religious law. And to do so, I'd like to consider the following case. Imagine for a moment two parties submit a dispute to a rabbinical arbitration tribunal. Imagine imagine a case you like, wrongful termination. And one of the parties is about to bring their star witness. They sign arbitration agreements. The party's quite confident that all will work out well. They bring their star witness, put their star witness on the stand, and the arbitrators say, I'm sorry, we're not willing to hear this evidence. The party asks why, and the arbitrators say, well, your witness is female, and under Jewish law, we're not willing to hear a female witness, and therefore we won't allow the woman to testify. You can imagine this party being somewhat disappointed. Now, this disappointment happens incredibly infrequently. One of the things that I discovered as going through this, there's no actually reported case of this happening, actually this type of challenge in a U.S. court in the United States, even though it periodically happens, but there's no reported case along these lines. That's largely because Jewish law has adapted in ways and changed over time to provide a variety of exceptions to this rule, where to the point where the exceptions largely swallow the rule. But it's a useful case. Even though it pretty much never happens, it's a useful case. And let me say a little bit about why. The classic lawyer response to this case is, this is an easy case. Religious arbitration or rabbinical arbitration tribunal has refused to admit female testimony. The statute prohibits this, the lawyer says. In fact, lawyers on the phone said these words to me. The statute prohibits this because the statute says that anytime you have an arbitration award where, quote, the arbitrators were guilty of misconduct in refusing to hear evidence pertinent and material to the controversy, a court can't enforce the award. And so they say, the lawyer says, reasonably so. This is a case where a court would vacate the award. Why would it vacate the award? Because the arbitrators refused to hear material and pertinent evidence. The woman tried to testify, they refused to accept it, ergo, the award can't be confirmed. I think this is a mistake. I think this is just an outright mistake of doctrine. And to understand why, consider the following parallel hypothetical. Imagine you and I sign an arbitration agreement and we decide to incorporate, via choice of law provision, the laws of another country. Just a hypothetical country. I'm going to pick Switzerland for absolutely no reason. Imagine we incorporate Swiss law for a moment. And imagine Swiss law has the following procedural provision. The procedural provision is that Swiss law refuses to admit video evidence. They're terribly worried that somehow you can manipulate video evidence. What are those kids doing with those computers these days? And so they say there will be absolutely no video evidence. So now imagine you have the same type of case. Two parties come before the arbitrators. One says, look, I have video evidence of the crime or the tort or whatever it is. And the arbitrators say, well, Swiss law says that we can't admit video evidence, so we're not going to admit it. And then the party then brings a challenge and says, well, you can't confirm this award because the arbitrators refuse to admit material and pertinent evidence. One can only imagine that a court in this context would say that evidence wasn't material and pertinent. You signed an agreement with the choice of law provision. That choice of law provision said the following evidence would apply and the following evidence would not apply. And so in failing to admit video evidence, the arbitrators actually were failing to admit evidence that was not material and pertinent, as defined by the choice of law provision. A relatively straightforward response. it's hard to see why we should treat the female testimony cases any different. And in this way, you begin to see the way in which a choice of law provision, regardless of context, whether it's religious law or other law, treats religious law like law. Because you have a choice of law provision, that choice of law provision gets to define the terms of the arbitration. It gets to decide what evidence is material and pertinent and what isn't. It gets to decide what type of notice is adequate and what isn't. That's the selected body of law by the parties. And so if you were to see this type of challenge to a religious arbitration award, the fact that religious law is law would pretty much cut it off at the knees. One can't simply say, after selecting a particular body of law to apply to a dispute, that it should not govern the procedure rules contrary to the intent of the parties when they would want to have the dispute resolved. Now, when I say this, sometimes people say, well, this is all well and good. Maybe religious law on this front is treated like law. It gets, like any other choice of law provision, it gets to define the procedural rules for the dispute. Some people say, well, maybe the award in any event should be vacated on the grounds of public policy. We can have that conversation. I'll say a couple things about it in a second. But to the extent you do that, that would be true of any other choice of law provision, any other selected body of law, which if it ever undermined public policy, it could be vacated by the court when a party tried to confirm the award. Let me just say why I don't think under public policy exception would do anything in this case. One is the Supreme Court's decision in 2007. I mentioned how pro-arbitration the Supreme Court has been. In Hall Street Associates v. Mattel, the Supreme Court said the only way to vacate an award is based on statutory grounds, not non-statutory grounds, and the public policy exception is non-statutory ground. And people are no longer sure if the public policy exception even applies. Even if it applies, it has to be evident on the face of the award. What testimony was and was not accepted may not be evident on the face of an award. And moreover, public policy, the Supreme Court has said in 2001, is defined by positive laws of the jurisdiction. And it would be hard to find a positive law of a jurisdiction that prohibited arbitrators from rejecting female testimony. All these things might be good reasons why the public policy exception might not apply. I think there might be other doctrines that would work. Let's all cabin that off as an aside for now, and let's just say the following. At first glance, religious law is treated like law for the purposes of procedural challenges to religious arbitration awards. Like any other type of law, it gets to define the terms of the arbitration. And in this way, importantly, obviously, religious arbitration awards are insulated from certain types of review. They get certain types of review, can't penetrate into the religious arbitration decision, and that's because we allow religious law as law to define the terms. Now, as I indicated at the outset, of course, this is only half the story. There's a hybrid approach, I would say, to the way in which religious law is treated, and so I've got to tell you the second half, otherwise it's just Unitarian. That's not nearly as interesting. So, while religious law is sometimes treated as law, it's not always treated as law. Now, consider the following. Go back to our hypothetical. So let's say our litigant says, we're not really a litigant, we're in arbitration, but the party says, fine, this is all well and good, that you say, well, this is how to define material and pertinent based on the nature of the law. But part of my claim is that you've gotten religious law wrong. In fact, they might point to the fact that there are ample sources in Jewish law that say arbitrators have the authority to accept female testimony, and in failing to do so, what you as an arbitrator have basically done is by getting religious law wrong, you have once again failed to admit material and pertinent evidence. And this would be, I presume, in part their claim when they raise this type of procedural challenge. Of course, here's the problem. As soon as we claim that religious law, that the arbitrator got religious law wrong, we're starting to make the type of claim that courts are not considered competent to resolve. Courts can't decide when what religious interpretation of religious doctrine is correct and incorrect. And so as soon as this procedural challenge moves to a claim premised on the correctness of the religious law, the procedural rules, the court would be disabled from resolving it. The court would simply have to say, we are hands off, we can't address this type of claim, this is not for us. Now this would not be true of other forms of law. Let's say you had, let's go back to our Swiss choice of law provision. In such a case, if there are an argument as to whether or not the arbitrators got some sort of foreign law correct and incorrect, at a minimum, a court would be able to evaluate the claim on the manifest disregard of the law standard. A court could determine whether or not the arbitrator's application of the law was so egregious that it amounted to a knowing and intentional violation of the applicable rule. And in this way, you begin to see the way in which religious law, while it defines the terms of the arbitration like any other law would, at the same time it can't be interrogated like any other form of law would. It puts it in such a powerful position, religious law. On the one hand, it gets to define the terms of the arbitration, and yet at the same time the court can't interrogate that religious law to determine the veracity of its interpretation. And again, this dynamic that religious law is both law and religion insulates religious law from various types of review by court. On the one hand, it gets, again, to define the terms. On the other hand, courts can't figure out whether or not it's right or wrong. So, thus far I've tried to kind of present the way in which, through the prism of procedural challenges to religious arbitration wars, the way in which religious law is in a unique position. On the one hand, it's law. On the other hand, it's religion. And as a result, this dynamic serves to insulate religious arbitration awards from certain types of review of its procedures. So what should we make of all this? Maybe nothing. It's procedural challenges to religious arbitration awards. That's kind of boring. But on the other hand, I think it says something kind of important. Well, what do we want going forward? Do we like this hybridity? And I'd like to kind of sketch very quickly 3 different takes, maybe, on what we should think of this kind of hybrid approach. The first approach to this kind of hybridity, the way in which religious law is both law and religion at the same time, and therefore it insulates certain types of decisions of, let's say, religious arbitrators from various types of review. The first approach, let's call it rejection. Maybe we should say, we don't like any of this. This sounds all bad, because once it's in the system, we don't have a lot of leverage, judicial leverage, to kind of pick it apart. And if that's true, maybe we should just simply close the courthouse doors to any type of religious law. Now, I would say this might be a charitable way, and unduly charitable in my view, to think about the recent wave of anti-Sharia laws, which aim to prohibit courts from considering religious law in their decisions. Maybe the thought is, well, you know what, once it's in, we can't interrogate it, there are all these doctrinal problems, and so maybe we should simply reject it. Fortunately, this is obviously not kind of the idea behind the extremely unfortunate wave of Sharia laws, but maybe this is a way to think about it. Maybe rejection of all types of religious law is not a terrible idea. I'd like to suggest to you it is a terrible idea. And the reason it's a terrible idea is, besides kind of the invidious discrimination behind such laws, there's also a forum problem. And the forum problem is as follows. Religious arbitration plays an extraordinarily important gap-filling role. And here's simply put, consider the termination of a rabbi for cause. Imagine you have an agreement where you have a contract buried 10 years unless some sort of cause arises. Actually, one of my favorite cases in the context is in the context of an imam who's terminated for giving bad sermons, which I think is, I would wish on many occasions. That's cause, I just heard it. But it doesn't quite work that way. You know, it doesn't, in any event. So imagine such a case. Now, if you have no arbitration clause and you bring this before a court, so what's going to happen? One party puts on its case, and you know, its case says clearly these sermons are terrible. The congregation says, just look at them, we have videotapes, judge, this is a disaster. And then the rabbi, imam, or pastor gets up and says, no, this is quite excellent, actually. I'm quite proud of this one. And you look at the number of YouTube hits it's gotten, a variety of it, can go back and forth. Obviously, a court is disabled from resolving this type of dispute. This is a core religious dispute that can't be adjudicated by court pursuant to the First Amendment. So now what happens? Well, what basically happens, unless there's a religious arbitration provision in a rabbi or imam's contract, is you're in a rabbi and imam loses system. Because any time that you think about it, the rabbi doesn't have his paycheck, the congregation has the paycheck. And the court needs to be hands off each time and says, we need to dismiss the case, there's no way for the religious leader to ever get a hearing on whether or not there was in fact cause. The only way you get a hearing is if you send this to arbitrators. And arbitrators can resolve these disputes, and once they resolve it, their award can be enforced by a court. And so in this way, religious arbitration plays an important gap-filling role if you say, rejection, we will not have religious law in U.S. courts. If the arbitrator's decision was in any way based on religious law, courts should be prevented from considering or enforcing that award. What you've done is you've taken out that important gap-filling role, and I would suggest for that reason alone, rejection is not an option. Rejection would leave a variety of individuals without a venue in order to have their claims heard. Okay, so let's say rejection's not the approach. Let's kind of swing to the other side. Let's say maybe deference is the approach. Maybe the way to think about all this is deference. And this deference kind of fits with the larger kind of story about religious institutionalism, a lot of writing, maybe the Supreme Court's recent decision, Hosanna Tabor, EEOC, that ceding authority and autonomy to religious institutions is a really good idea. We should celebrate the fact that certain types of religious arbitration decisions are insulated from various types of judicial review. I think that's not a fantastic idea either. And the reason I think that's not a fantastic idea is because deference means limited judicial oversight for procedure. And this is exactly what parties to religious arbitration want. They want the arbitrators to resolve their dispute in accordance with religious law, both procedural and substantive. And if there's absolutely no mechanism or method for courts to interrogate whether or not the right procedures were followed, whether or not, both in terms of how we define the terms and maybe more importantly is whether or not the arbitrators got the religious law right, then we can't guarantee members of religious communities that they have access to the type of religious forum that they're seeking. Now, when I make this claim, of course, most typically the response I get is, well, the First Amendment requires this type of insulation. I'll say a couple words about it in a moment, but I don't think that's right. I think there's far more kind of room in the joints to allow courts to interrogate certain types of religious questions than current constitutional doctrine grounds. But as a minimum, from a policy perspective, I think there's definitely a real danger to pushing deference too far to the point where there's no judicial oversight of these types of procedural decisions. Okay, so religious law, it's hybrid. How should we think about it? Maybe we should go with rejection. I don't like that idea. I reject rejection, if you will. Maybe we should go with deference and keeping certain trends in constitutional doctrine. I think that's not a fantastic idea either. And so what I'd like to suggest, ever so slightly, is that we begin the process of demystifying religious law. Or put differently, I think we might benefit from increasingly thinking of religious law as more like law than religion. And what that would mean is we allow courts to interrogate, to some extent, the application of religious law, just like we do other forms of law. Now, before any of you seek to lynch me on First Amendment grounds, I would actually suggest to you that this was the prevailing doctrine. Supreme Court's early First Amendment approach from, I'd say, 1871 through 1952, for the common law buffs out there, from Watson to Kedroff, where courts were actually authorized to ensure that religious institutions made decisions in keeping with their own internal religious rules and their decision-making processes. This is actually quite common, relatively common. There are fun notes in the Harvard Law Review that talk about how courts regularly dealt with religious questions. This is what we know in the Yale Law Journal, I think, in 1965, saying this was the prevailing law at the time. There seems to be a significant amount of evidence that the First Amendment has applied in earlier years, allowed courts to make sure that the process that religious institutions use in order to make their decisions were in keeping with the rules that they internally adopted. If we adopt such an approach, in the question and answer period, we have kind of more questions about how it comes to this conclusion, but if we adopt such an approach, what we might do is authorize courts to investigate religious doctrine when it comes to determining whether a religious tribunal has willfully misapplied religious procedural law, such as the failure to admit female testimony. Now, this doesn't mean that I'm endorsing free reign of courts to inject themselves into every religious dispute and decide what should be and what shouldn't be. But demystifying religious law would ensure that where religious tribunals intentionally manipulate religious procedural rules, courts can step in and uphold those very procedural rules based on the intent of the parties in entering this alternative forum. Limited by arbitration doctrine to those instances treating religious law like law can serve as a tool to protect religious parties from procedural misconduct by upholding the religious law and incorporate it into the relevant religious arbitration agreement. In so doing, seeing religious law as more like law and a little less like religion can help protect the institutional infrastructure that makes religious freedom possible. Thank you.
Thank you very much. I want to allow the speakers to talk a little bit among themselves, and then take some questions. I want to begin to put Tim and Michael in dialogue. Okay.
Can I attack Michael?
Yeah. Do you want to do it before I put you to the dialogue?
Not physically, right? You're just going to ask a question.
Yeah. You say private. The private group can solve the problem, Tim, right? And Michael, you say that that the government has to be turned to solve the problem, the gap filling problem, for example. I mean, do you really think it is impossible to imagine the community evolving in such a way to ensure, for example, that that the rabbi or the imam not always be a loser? It might involve less decentralization of the of each synagogue or mosque, but you can imagine the money, for example, being held by another entity. Anyway, I'd like you to think about it.
Do you want to build on the attack? Or?
No, my attack's independent of my thesis about private entrepreneurial regulation.
Oh, great. Okay, so maybe I'll take that. So just to be clear, I think that piece of the gap-filling role, I think, is where we need religion, and courts can't do enough. I mean, those are instances where courts lack the constitutional authority to resolve the dispute list, at least as currently understood by the Supreme Court, which I disagree with for a whole bunch of reasons. But as currently understood by the Supreme Court, where you have a religious dispute that entails resolving a question of religious doctrine, courts can't do it, and I think that's where we need religious arbitration to fill that gap, to make sure people have a place to go, arbitrators to resolve the dispute. What I worry about, I'd say this is kind of like larger, like meta project. Like, I find it consistent no matter what I look at. This is what I see. What I see is I would like religious institutions to generally be in charge of substantive decision making. And what I want the state to be doing more generally is kind of on the edges, making sure that we don't have kind of what the Supreme Court referred to in 1929, Gonzalez, as fraud, collusion, or arbitrariness, a certain type of kind of checking on the procedural margins to make sure there hasn't been some sort of underhanded dealing or that religion isn't being used to cover or as a pretext for something else. So I actually relegate, in my view, the state in these matters to a real secondary role, but one that exists nonetheless, one that makes us feel more confident that the worst parts of religion aren't seeping into the decision-making process that's confirmed by courts. So I don't think I see a major role to the state, but I think that's an important role. It makes us feel confident, makes us feel more confident. And I think in the end, whenever religion is being applied by humans, the possibility of misconduct looms large, and to the extent we can leverage the state to deal with those things, I think we're better off.
I wanted to question this idea of treating religious law as law, which I take it as your sort of middle ground, moderate solution to the problem of oversight of private arbitration awards governed by religious law. And it seems to me that this assumes a kind of determinacy of religious procedural law. And insofar as religious procedural law is a version of common law, if you look in the common law and you were to ask a tribunal, a civil tribunal, what's the common law of such and such a jurisdiction? The answer to that question generally is whatever the Supreme Court of the jurisdiction says it is. And looking beyond that is pretty problematic. And Lena's presentation suggests that this is a general problem in law, especially law that has a common law character, that there's such a high level of indeterminacy that the role of the law is not to find the philosophical answer to the question what the law is. The role of the tribunal is to figure out what's the practical solution that the current tribunal will impose. So I think to some degree you're assuming that if we treat religious law as law, that somehow we're demystifying it. And as someone who teaches common law as opposed to constitutional law, common law is notoriously mystical. That's part of its power in some way. And I would suggest that we already have the tools to deal with oversight. And those tools are standard, garden variety, constitutional concepts like rational nexus, due process. I'll give you an example. If you want to know whether or not female evidence or video evidence is material and pertinent evidence, my guess is you could subject it to the test of, is there a rational nexus between the exclusion of certain kinds of evidence and the desire to get to an adequate record on the basis of which you can make a rational agreement. We have these sorts of reviews in administrative law all over the place. We subject agency decision-making to this all the time. We say agency decision-making may be somewhat mystical, but the fact of the matter is we have constitutional guidelines that say there are limits In the kosher context, this occurs in antitrust. Many people will tell you that Jewish doctrine says that if you poach a client from an existing heksha, an existing certifier, that's not allowed. You're not allowed to do that. It's against Jewish competition law. And the question is, will courts weigh into Jewish competition law? And the answer, I think, probably is no. All courts need to do is say antitrust law establishes certain standard principles like competition. And on the basis of those principles, constitutional principles or antitrust principles, doesn't really matter, can police the boundaries by which private adjudicators or private organizations can conduct their religious business. So I actually feel, to some degree, it's much easier to just draw on the existing tool bag. And you can demystify religion by saying, we're going to treat religion like any other arbitration wars. There's a rational nexus here. And if there's not, I don't care whether it's a Muslim irrational nexus or a Jewish irrational nexus or just a business association's irrational nexus.
Can I interject?
Pile on, please.
No, I think that you're actually doing what he's saying he wants done, which is to analyze Jewish law as a legal system. And the analogies that you're making show that your analysis is precisely that. And that's actually what Michael was trying to do, is basically to say, take out the religion part of it, think about it as a legal system, and then treat it like a legal system. That's why the analogy to Switzerland was so significant. In your analogy to common law, it's significant. So that's how I read you.
But my solution wouldn't be to dig into the common law or dig into the religious law, to let courts engage in this inquiry. All I would say is,
ignore it.
But no, the courts ought to subject the decision or the procedural rule, whatever it is, whatever the arbitrator says the rule is, to subject that rule to constitutional norms of rational nexus or due process or whatever else is available, that courts are in the business of policing private exercises of authority or public exercises of authority in that matter.
So I wish, first of all, I buy the whole common law way that Lena just described. I definitely buy the common law analogy. Here's what bugs me. Here's what really bugs me. What gets me going is when I read these New Jersey decisions that say the following. They say, in a series of defamation cases, what they say is, we agree that there are no competing theological propositions here. Everyone agrees what the religious law is. That notwithstanding, we think that there are First Amendment entanglement problems, and therefore we need to dismiss the case. Now, this is a curious move by various courts. If you're treating it like common law, we would say if there were no competing conceptions of the religious law, well, that would maybe we would take judicial notice. I don't know exactly. We can talk about procedurally how we would do it. But in instances where there are no competing theological propositions, where everybody knows that the claim about religious law is false, or is manipulative, or is misconduct worthy, what we would do is exactly what you suggest. That's actually not what's happening. What's happening is the opposite. And that's what's preventing courts from engaging in what the Supreme Court called in 1929 marginal civil morality. The Supreme Court in 1976 said we can't do this anymore. This violates the First Amendment. Anytime we see ourselves as kind of entangled in some sort of religious controversy, real or imagined, courts need to run the other way. That seems to be a real problem. So I'm completely with you on treating it like some form of common law, but it's just not what's going on. Something very different is what's going on.
I'm not arguing that you didn't identify a problem. I'm just arguing that the solution you provided was in some ways has assumptions about what courts are capable of doing, that in fact courts already have a more modest way to police these sorts of issues using standard garden variety constitutional concepts like rational nexus.
I wish they would use rational nexus, things like rational nexus. And my worry is that when we say when there are no competing theological propositions, courts need to run the other way. Now, I am with you on another piece of the analogy also, in terms of common law. Let's say we had some sort of issue where the religious law were so fraught that it was hard to figure out what the correct answer is. And my view is, again, we should use common law intuitions. If it's so fraught, then you can't satisfy your burden. Think about, like, I talked about this, not concept of arbitration, but like a contract. You had like a contract, religious term in it. And so what you would do is where you had conflict in this area. You know the chicken case, there's a famous chicken case. Anybody know the chicken case? Famous chicken case for Albany.
Where I study, there are lots of chicken cases.
Oh yeah, that's right. So there are two parties that are fighting about what the court begins the decision by saying the key question in this case is what is chicken, and I enjoy teaching this case. And so the question is, does it mean broiler or stewer? And so there's a big fight, and everyone's bringing evidence, and done it's going to change the market price big time. And the court in the end says there's so much competing evidence on both sides that the plaintiff can't carry their burden, so we need to dismiss the case. I think we treat religious law very similarly. When they're so fraught, when you have kind of, your rabbi says this, my rabbi says that, and we say it all the way down from from the beginning of time till now. So then courts can say, listen, we can't resolve this. What I want is kind of, again, in keeping with your intuition, we should exercise more of these common law intuitions, that where we can, on the margins, where we can demonstrate that what we have is the result of fraud, manipulation, undue means, etc., courts should use the standard fact-finding and interpretive techniques, in this case, by treating religious law as law, as any other form of law, in order to police the most extreme forms of misconduct. I think that's powerful. I think that can make us feel more confident in the type of religious dispute resolution we get, and make us feel, again, much more confident about the religious freedom that we have.
Would it be good to get other participants? Professor Boyd?
First of all, it's been a long time since I've been to three panelists quite as very well done as this. This was really excellent. I had a question about to follow up on your suggestion, Tim, and then apply this to Michael. Maybe a better model is Chevron administrative deference. We have this very unusual situation. In 1 year, the Department of Labor says the rule is X. And the court says, okay, X is a good rule and a reasonable interpretation. The administration changes. The Department of Labor says, well, no, now we've decided that the proper way to understand the statute is Y. And the court looks at it and says, okay, it's Y. Y is reasonable as well. And you scratch your head and say, well, is the correct interpretation X or the correct interpretation Y? And the court says, yes, that's right. The correct, it's reasonable to interpret the statute X or Y. We're not interpreting the statute. That's not our role under Chevron deference. Our role under Chevron deference is only to ask whether this interpretation of the statute that the agency is interpreting is reasonable. And maybe it's not common law adjudication working in the background at all, and thus not determination of what's the law of Switzerland or what's the law in Alabama, and which of these two is more reasonable. But there's a recognition of the fact that we have here, so to speak, an administrative agency. And the administrative agency has a certain amount of deference. It not only has more expertise in determining what the statute means, it has the right to change its mind. So in 1 year, it can interpret the statute to say X, and in the next year, it can interpret the statute to say Y, and the court will accept the X interpretation, and it will in a subsequent year accept the Y interpretation. And this thus doesn't put the court in a position of determining what's Jewish law, which might really be an impossible task, but it might instead just put the court in a position of a more reasonable question to ask the court, which is this a reasonable interpretation of what's going on? And if you think about it in terms of kashrut, that's really become, for example, what state kashrut agencies do, which is they don't really determine what's the precise kashrut standard out there. But when I make the claim that pig's feet are kosher, the state agency, I think, says no, pig's feet are not kosher. But when I make the claim that regular milk is kosher, or that this is exactly my tradition for deveining meat, a la the Long Island butcher case, the state says, okay, that's somewhat reasonable. We can't really determine how exactly the deveining process has to take place, because there are a variety of traditions. So I just wonder if the search for exactness is possible, and maybe administrative deference, not rational basis, but Chevron deference, is a better model for what courts should do.
So those are two instructive examples, I think. Let me start with kosher. It turns out that while 22 states have kosher fraud laws, and originally all of those laws made reference to the standard of Orthodox religious requirements, 5 of them have been struck down and the rest are running for cover, because the federal courts have found that states cannot enforce a religious standard. So what's happened is they switched to what's called disclosure laws. So in the state of New Jersey, if you label something, if you label pig's feet kosher, as long as it says pig's feet kosher under Aunt Bubby's certification, as long as you have documentation that there is a real Aunt Bubby and that she did come by to certify the pig's feet, That's kosher in the state of New Jersey. In fact, I was actually told by the chief enforcement officer of the state of New Jersey for 20 years that you can call pork kosher as long as you have a certificate showing that somebody actually certified it as such. So in that sense, kosher is steered away from this. It's very much in the territory. But Chevron deference is also a remarkable example because in administrative law, just some background, Chevron deference is a doctrine from a case involving Chevron Corporation in which the Supreme Court said that it wasn't going to get in the business of deciding precisely what a statute meant for the purpose of enforcing the statute, a regulatory statute. It was going to simply defer to the agency as long as the agency's interpretation of the statute was reasonable. And it turns out that in order to determine whether or not the statute is reasonable, you have to engage in a significant level of interpretation about what the statute means. And when you look at statistical studies of how the Supreme Court uses this doctrine, which was supposedly a revolution, it turns out that in about 50% of the cases that would involve Chevron deference, they cite Chevron deference and they defer to the agency. And in about 50% of the cases, they don't. And it's very hard to determine when they use the rule and when they don't, which leads many people to believe that they're actually never using the rule. They're just interpreting the statute, and when they want to favor the agency's interpretation, they trot Chevron out. So I'm not sure that deference actually provides you the level of determinacy or hands-off religious doctrine that you're suggesting. I don't know that that would solve my problem.
I absolutely love the administrative, I've talked about this elsewhere, I love the administrative agency paradigm, and I think I'm actually using it, and kind of your example of reasonableness I think will help ferret this out. Look at what you do when you want to figure out reasonableness, right? So the first thing you do is, we need to figure out it's reasonable. Move number one is what? How do I know how reasonable something is? Well, let me just try and see what the interpretations available might be, right? That move in the context of religious law under kind of our First Amendment doctrine is unavailable. I can't even begin the process of figuring out whether something is reasonable by comparison to the interpretation of the law because I, as a court, am disabled from step one of that analysis. And that, I think, is the core problem. The problem is, and I think that I would want, as a general matter, first of all, in the substantive merits that I explained, I think courts can never do anything here. But in areas of procedural misconduct, if I want to figure out if something has gone so far from the reasonableness inquiry in the middle, like everyone agrees, in contrast to these New Jersey courts that really just bug me so much, where they say no theological propositions. Everyone agrees that the religious law is X. They did Y, but we can't get involved because it's religious law. That's so deeply problematic. And the only way to stop that type of that type of constitutional training is to allow step one of the inquiry, which is, well, what does religious law potentially, reasonably, possibly, even in your most extraordinary interpretive, with your most extraordinary interpretive hat on, what can you come up with? We can't engage in that admin-like analysis because we're foreclosed by the First Amendment. So I think that the instances where this might actually come up, where you actually kind of police religious arbitration awards or procedural challenges to religious arbitration awards are extraordinarily minimum. They'd be more infrequent than you would in administrative law. But what you would be policing would be the obvious misconduct. You wouldn't allow parties to say things like, this is religious law, and therefore you are completely foreclosed from any type of interpretive analysis. We should allow the standard types of fact-finding we allow even when we go for extraordinary forms of deference, whether you want to call it a rationality review, reasonableness review, manifest disregard of the law review, whatever kind of legal context you're in. Those extreme areas of review that we allow courts to do on the outskirts of various areas of the law, we don't currently allow them to do when it comes to religious law. And it's in those most extreme cases that I'm advocating thinking of religious law as a little bit more like law.
Yes? I'm going to reveal my ignorance of how all this works. I'm completely new to this.
I just did that, so.
Oh, okay. So, perhaps you just correct me on this procedure, but the hypothetical scenario that you outlined, in which a plaintiff is blindsided by an arbitrator who doesn't admit evidence, strikes me just on the face of it as just a careless arbitration agreement. Like, in other words, did they not have the freedom to sort of know how the arbitrator thinks about religious law and the freedom to not submit to an arbitrator who would so callously prejudice against them? I mean, I guess my question pushes sort of this the more deference side of it. In other words, really what should be required is kind of full disclosure of one's interpretive framework, etc., and an agreement prior to sort of a common agreement on what the religious law entails, etc., and freedom to submit or not submit to an arbitrator who's not going to be who's going to be so unfavorable. Am I just misreading how this all works?
No, that was that's great.
That's the perfect link, though, between the two talks, because you're suggesting that what we need is a state-backed solution to the problem of disagreement within the religious community about what a legitimate arbitration panel's behavior is. And the questioner just suggested, I thought, that we could actually adopt some other mechanism, which would be a market mechanism. We call this forum shopping in the law, which is generally pejorative, but forum shopping could be celebrated. And you could argue that actually there already is, but we could develop a better private market in arbitration forum. And then people could say, I want to go to more or less, or a medium, or vanilla, or a chocolate forum to figure out what kind of procedural law I would expect. And as the law develops and the market develops over time, and the information necessary for the market and the competition for the market and the branding and the you have to deliver on the branding might actually do better than your attempts to try and invoke state backing, which has all these problematic First Amendment overtones.
There's a lot of really interesting literature on kind of market forces and arbitration. So let's just talk about some ground rules that are making it difficult. One, arbitrators don't have to issue written decisions. Written decisions, but not explained decisions. So in theory, you could have an arbitration tribunal that one of their explained decisions has never seen the light of day. They also don't have to issue rules. Now, so there is no legal requirement to make information available in stark contrast to disclosure under the Kosher law. So one option would be to reform arbitration doctrine and just require for all arbitration. We couldn't do it just for religious arbitration. That would actually violate the First Amendment. But we could require disclosure. Now, here's the problem with disclosure. What would arbitrators let's assume that we don't, reform all of arbitration doctrine. Let's say we just say, well, maybe they should disclose in the interest of market forces. So I think Judge Posner has an article on, I think it's Judge Posner, please forgive me if I have this wrong, talking about, well, it makes sense, I know he talks about it, I just don't know which way it comes out, how market forces will work in the context of arbitration. Well, arbitrators tend to disclose more or less. The problem with arbitrators disclosing, well, before this, let me just say one other thing. It's not trivial just to say what the arbitrators could disclose. You can imagine an infinite number of legal rules, Jewish legal rules, that they might have to disclose on. Like, which ones do you want them to disclose about? There literally could be billions. And I actually think that could be. There probably are billions. And so disclosure would probably, just imagine what those volumes look like. It would stop being disclosure. It would be like the agreement you signed with Apple for your iPhone, I'm just guessing, which you never read, but has a lot of things in it. If disclosure amounted to disclosing every interpretation of every Jewish legal rule, it would amount to nobody knowing anything. But let's leave all that aside for a second. Let's assume we can kind of either reform arbitration doctrine, which will never happen, or alternatively, we can figure out what we want disclosure about, which is also not something we're going to be able to do. Let's say we dispense with those two problems. Instead, we just want to know, what will arbitrators disclose on their own? The problem with more disclosure, at least with regards to substances, it's not clear if arbitrators are going to be incentivized to get more, if they want more business, to disclose more. Because the more people know about their decisions, there may be one party each time that doesn't want to go there. And so some people have suggested that market forces in arbitration actually push arbitrators to disclose less, which is a little bit of a problem. Now, maybe in the context of procedure, that wouldn't be as big a problem. The Lytton of America, for example, one of the most prominent rabbinical arbitration tribunal in the United States, actually has extensive procedural rules that are published online. But they're really, they're the gold standard, and everybody else is like, I don't know, iron. And so the problem is we're not getting disclosure. Now, maybe that's because of market forces, maybe that's because of lack of sophistication, maybe that's in part because there's no requirement to publish decisions. I love the idea. If we could figure out all those little problems that kind of lurk behind the suggestion, I'm completely on board with disclosure.
Couldn't the plaintiff's lawyers just go and say, are you going to admit female evidence or not?
Well, they could ask about that. What list of things would you want them to ask
Or just
about?
leave it up to the lawyer. Or just leave it up to the parties to ask the questions. And if the arbitrator doesn't answer the questions, well, that maybe they shouldn't go with that arbitrator.
Yeah, it's possible. I just worry about what's the list going to look like. It's going to be, especially if you're paying $400 an hour. That's going to, and how much are you paying the arbitrator to answer the questions? I don't know. I think disclosure is a great idea, but we can work it out.
Professor Fleishing?
I have one procedural note first, and then I have a question for Lena. As some of you have been doing and leading the way bravely, I think, you should all be aware we're not going to have time for a break before lunch, but you're getting a little peckish. Please come up at any point, take a little something, bring back to your place in any point of the discussion. And then for Lena, I wanted to ask, I love the discussion about the historical context for Al-Una and for Al-Una, the army period and Arbitration. You hinted that you have thoughts about how this might apply to how we understand divorce, Jewish and Islamic divorce law in the American context. I sort of want to invite you to take the opportunity of saying, do you see ways at this point in which either Islamic or Jewish divorce procedures, traditional Islamic or Jewish divorce procedures, are changing in the American context? What are your thoughts about that?
So I'll give you an example from Egypt. In 2000, they passed a khul'a law, which is a wife-initiated divorce law, as a means of facilitating women who want to divorce their husband, basically, instead of waiting for their husbands to divorce them. So it's based on the Islamic chronology, which I didn't give in this talk, and based on the Islamic traditions that have kind of been marginalized over history. In very much the same way that I argue the Jewish practice, the rabbinic practice, was marginalized over time. So in the States, I think, I'm sort of worried about commenting about this with Professor Boyd here still, because I think he knows this so much better than I do.
You're just invited to contradict you.
Yeah. Well, I think that the point is, for me, the point of the paper is more that the fact that there's a state that's doing something affects how the religious community understands its own traditions. So for me, the point of the story is that the Gaonim were practicing something and they understood it as being Orthodox rabbinic practice. And then other people came along and said it's not because you were influenced by the Islamic State, right? The fact that it's Islamic is actually kind of irrelevant. The point is that it was the state. And that's what I see happening here. So even though you have the New York's case law that I presented at the beginning, is it really affecting things? There's still chained wives. There's still, I don't know, there's still women who don't get divorces and are still stuck. And that, he raised his hand and said, yes.
First of all, I thought your presentation was spectacularly interesting. I had nothing contradictory to say about it.
But you know more about the U.S. context, contemporary business.
But I'm actually much more interested in the Talmudic conversation that you started. We could talk about New York law, but why bother? My question goes as follows. I wonder if the medieval discourse was genuine. What do I mean by that? I wonder if those who are criticizing the Gaonim really cared a whit about whether they were influenced by Islamic law or secular law or anything else. What they really meant is, you're inconsistent with the Talmud, so we're not going to do it. And as to explain why you were inconsistent with the Talmud, that sort of, people can't help but be biased by their environment, so they sort of shrugged it off. To this day, so to speak, it's an ongoing conversation in rabbinic jurisprudence, which is when I want to shrug off somebody, I sort of say, oh, a product of his times, as opposed to me, I'm timeless. And correct, you're a product of your time. Not me or you, I'm just, I wonder if to determine if this was genuine, it's necessary to really know any Islamic law or any secular law, state law in the years of question, or just to really ask whether the Rishonim who shrugged it off were just saying, we don't think this is the right rule, sort of like you said about Chevron deference. After we determined it's the wrong rule, why we explain to you it's the wrong rule is sort of somewhat an arbitrary choice. We could say you're too secular. We could also say you're too religious. We could say, oh, you're too this or you're too that. But I thought what was really running in the critics of the Gaona was just they thought they got the rule wrong. And once they got the rule wrong, you then have to ask the following religious questions: how can great minds get the rule wrong? So they say, well, great minds are influenced by their times, or great minds aren't influenced by their times, or great minds had something bad for breakfast, or whatever you need to say to explain why a great mind got it wrong, you sort of say. But that was my real underlying question, which is of much more interest to me than asking what's really going on in New York today, even though maybe that interests more people. I wonder if you thought the discourse was really genuine.
I see what you're saying, and I think it's probably a mix of both. I don't think it's either genuine or not genuine, right? That there's both strategies going on. And there's definitely, I found, I'm looking at one of my sources, I found this one source that hasn't been discussed very much that talked about it as being an issue of Western versus Eastern authority. And so what I find really interesting, though, is just that for hundreds of years, there are all these rabbinic Jewish communities in the East who are doing this. And then one day these rabbis come, right, and at some point in the 14th century, and then say, what you've been doing for hundreds of years is wrong, for precisely the reasons that you're saying, right, that they got the Talmud wrong. But they never understood themselves as getting the Talmud wrong. And how did they manage to convince all these people that they did get the Talmud wrong, such that they, abandoned their own practice, their own internal communal practice? It's an interesting question. But you're right.
Communities abandon their own internal practice?
Eventually, yes.
But really it's because those communities disappeared. It's not quite my historical reading is that the communities that adopted their own practice really continued to until what we socially call Gaonic Judaism disappeared. And not because of this issue, it disappeared because of social factors.
They stopped earlier when I mentioned the two rabbis who moved from Spain to North Africa, that they were very influential in basically stopping those communities, and then those were the main communities who were practicing, right? And then gradually yes, they stopped doing it, right?
But I sense it's part of in the sense of the land of the Gaonim.
Yeah, no, it is part of the process of the Gaonic, but it is true that obviously the Jews in that part of the world are gradually becoming smaller and smaller communities. Absolutely. But there's also an interesting issue in which the authority shifts, right? So that the Gaonim had their own individual authority, and those centers of authority moved right westward, so that it's the Rishonim, Western Rishonim, who become authoritative in some way, in terms of the practice.
Right, but while the Gaonim were authoritative, they never gave up on this in the face of criticism.
No.
That's what I find very interesting. They weren't criticized, they sort of said, drop dead, who are you?
Well, they said actually more than that.
Exactly.
They said we've got the Talmud right. We have a continuous tradition. We're sitting here in Iraq, and this is actually where the Bible was redacted anyway. And we're the ones who know exactly how it's interpreted.
I sort of summarize that as drop dead.
Yeah. And Rashi agrees with us. So.
I know they sort of dropped dead. They said more than drop dead, but they expressed it in that way. I mean, my sense is historically this disappears only really when the centers of authority leave those.
Yes. Absolutely.
I really mean drop dead. I promise that was a little bit.
But it was a great way to describe it.
Yes.
Well, so I think that some things that hook together here. It seems like the shift in the divorce decisions became gradually or suddenly more what we might call conservative, or am I understanding it right? Or more,
you could
or from a certain point of view, more oppressive to women.
More limiting.
More limiting, okay. And it seems like the market forces in kashrut tend, I'm not sure about this, but it seems this way to me, tend to push things rightward. A more strict supervision is going to convince more people that, oh yeah, we better do it this way. So that, and then in terms of arbitration, although I prefer more mediation than arbitration, but let's assume arbitration. I'm wondering, and I think these are connected, but I'm just not sure how, that how do we know in the case of two parties coming from a religious community coming for arbitration that one or the other isn't being coerced into this religious arbitration situation? by pretty intense, let's say, communal pressure. I mean, it could be a divorce situation. It could be, I don't know, it could be a question about kashrut supervision even. Like suddenly these restrictions are getting more intense, and it's 20 years ago we didn't have to worry about this, and now we do, and it's more expensive for us, and we want it arbitrated, but there's pressure towards bringing it to arbitration somehow that would have religious legitimacy in the eyes of the right wing. That tends to be, it seems, where the pressure often comes from.
I guess I could just start. I'm not sure the characterization that the open market forces for kosher supervision has led to a move to the right. I think it's led to a broadening. So there's an American mainstream, the American standard of kashrus, and that tends to fight off challenges from the right and from the left. If you want a stricter or more stringent standard of kosher supervision, you go to Borough Park or Flatbush and you can find people who insist on particular stringencies and that the community in those areas only eat food with those certifiers who follow those stringencies.
Hasn't glot become kind of normative?
Yeah, that's actually a big discussion that has more to do with industrial meat production and its pace than it does with standards. So just as an aside, if you want to get the most strictly supervised meat in America, it's Stom Kosher in St. Louis because they run 20 cows at a time. But that aside, there's also a sort of less stringent market for lower stringency. So if you want cheese that doesn't necessarily conform to the mainstream standard to get Talcade cheese, there's a broadening, I would think, that the market basically will support any range of kosher options for which there's adequate consumer demand. So I think it's a little bit different than what Lena's talking about, which is tightening up the pressure or the restrictions that conforms with this sort of larger wave of moves towards social vision, which I think is less true. The market is frequently like this. The market is somewhat more anarchic than that, and it allows for a variety of social visions. I mean, not to tell markets too much, but in kosher, it's provided a much wider range of options for people than the alternative system.
Well, I will say though, in the article version, I go into a little bit about the market relationship, because I think that there's something going on with basic socioeconomic factors that correspond to these changes in how divorce is understood, that are related to labor and related to employer-employee relationships, and the way that that becomes less, it becomes less possible basically to dissolve a contract without paying punitive damages. And that's partly what the underlying narrative is about these divorce cases, is that whereas at an earlier period in late antiquity, it was pretty commonplace for women to just give back their dowries, and that would dissolve the contract, and that would be it. That's the divorce. At some later point, it becomes not possible because you need to pay punishment for something that it's not enough for you just to give back the ketubah. You have to give the dower. You have to give back something else, like you have to pay for getting that divorce. So I think that there is something relevant to the market in the narrative, but we don't have enough historical evidence on the market structures to really give an elaborate story about it. But definitely the socioeconomic and the market structures are there.
Michael, thank you for your presentation. As you can probably guess, I'm very sympathetic to your point of view. But it requires a certain... Oh, sorry. Maybe
if you could just repeat the sympathetic part.
Yes, I'm very sympathetic to your point of view.
One more time.
But it requires a certain amount, I think, of internal coherence in the doctrine of being interpreted, so that an outsider to the conversation can reliably distinguish religion from non-religion, right? And it seems to me that this is always a problem that I hear from outsiders to the Islamic legal tradition. Well, how do we know that this is not a religious rule as opposed to just an ordinary rule, right? And they always seem skeptical when I try to explain that. Well, you know, Islamic law makes its own internal distinctions between what's a theologically motivated doctrine and what is not. And so that's sort of one question I'd like you to answer. What does it mean to say that treat religious law as law and not religion? Because that supposes the ability of the adjudicator to distinguish the two. Right? Now, it seems to me easy enough with our procedural rules. You know, if I enter into a contract with somebody and we agree to arbitrate, we could choose to create our own rules of procedure, excluding all rights of discovery, et cetera, et cetera. Nobody would say anything about it. But if we said something like, pursuant to this, our mutual understanding of Islamic law, we will not allow discovery, for example, then all of a sudden does it become religious? It's sort of a strange metaphysical question, which I think I would like to hear your sort of views on how third parties are supposed to distinguish it. Where parties don't spell out in painstaking detail what exactly they want the arbitrator for purposes of reviewability. And the second thing is, and I don't understand it, maybe it's just because I don't know First Amendment law as well as I do, but one of the ways, I guess, in which Islamic law is different from Jewish law is that there are various jurisdictions that actually purport to enforce Islamic law. Right? So sometimes you might have a contract in which the choice of law provision includes the law of the state that its own internal system would apply Islamic law. Let's say Saudi Arabia. So I'll give you an example. This is a decision from a federal district court in New Jersey, contract dispute involving breach of a contract for a sale purchase agreement. And the plaintiff in that case wanted to get damages when the defendant did not complete its investment. Right? And the issue was whether it should be expectation damages or just quantum merit. Right? And the court ended up saying, no, we're just going to give restitution because in Islamic law, which is based on Shari'a, they believe that only God knows the future, so it's impossible to calculate damages. Now there you have a pure theological interpretation, right, which would seem to be a shocking violation of the First Amendment, right? But somehow it doesn't come up at all because it comes up as a choice of law provision, right? Not as reviewing a religious arbitration. And so it's interesting to show how sort of arbitrary doctrinal rubrics, so to speak, drive judicial reasoning. Because here you have an open theological reason given, but it doesn't seem to trigger the First Amendment concerns about entanglement because he's construing a foreign law. He thinks he's construing a law of foreign state under a choice of law provision, not reviewing arbitration.
I think it would be only fair for me to say I'm sympathetic to everything you just said. And, I mean,
repeat it 3 times.
Yeah, I'll keep on going. I mean, as long as there's reciprocity here, we can cover it. In any event, let me just say, so you're putting me in an uncomfortable position because you're going to ask me to justify some First Amendment constraints that I think are bogus. Can I start with your second one? And I'm not really supposed to do that, but in any event, yeah, okay. Yeah, I think that's an excellent example. I have a much larger commitment, not in this paper, but kind of a larger attempt to explain plain language. First Amendment really should be seen as what we should be doing is granting autonomy to religious institutions over internal decision making, as opposed to disabling courts from interrogating religious questions. That's kind of my larger, this is like a piece of that larger commitment. I think that shift from moving away from deferring to religious institutions as opposed to what we now do, which is avoid religious questions, was a move made in the late 60s by Justice Brennan. It was a huge mistake that has led to lots of bad things. And I think the example you just gave, I think I even give it somewhere, like how religious law we say we can't figure out, but if it's a state that then has its own incorporated religious law and applies it, all of a sudden, where courts are completely competent. Now they understand it. Beforehand, if it's just plain old religious law, it's to use the Supreme Court's language, beyond the ken of mortals. Now that a state has done it, oh, this is no biggie. We can just, here we go, let's just break this down, we take the whole precedent, everything's fine. I think you're completely right. I think it's inconsistent, at least to those who think that the core problem is like Arluku and Robert Tuttle, who think that it's all about adjudicative disability, why courts can't interrogate religious questions. I think your example, and there are others along similar lines, is a really good indication as to why it can't be about institutional competency. What it really ought to be about is a question about what types of institutions we're deferring to. And that, I think, explains a lot more of the differences in the way we treat states as opposed to the way we treat religious institutions. I think that explains it as opposed to an issue of competency, which I think is, as I said, bogus. But kind of to your first question, in terms of how do you know, I mean, this is like a recurring problem. It comes up in a variety of areas of the law. So like think about like under the Religious Land Use Institutionalized Persons Act, where it's one of the great acts, right? Like institutionalized persons and religious land use are brought together in this one statute. And in that statute, what we require courts to do is determine that there's been a substantial burden on religious religious practice? Well, how do you answer that question as a court? The courts do it relatively routinely. We allow them to do it. We don't say that somehow you're interrogating a religious question. How do you know you've crossed the line from religious to non-religious? I don't think there's a very good theory out there about this, which is, again, why I think we should get rid of that whole framework. To me, the real question is, what is the institution you're deferring to, not what is the content of the law you're interrogating. The way in which this type of deference should work is substantive merits should be, we should be deferring to religious institutions to organize their own religious institutions, to organize their own affairs. I think we do that based on, I'm going to say this really fast, it's like an hour conversation, based on the implied consent of the members to the religious institution. And because it's based on this notion of either consent in the context of arbitration or implied consent in the context of religious institutions, what we really are doing is like kind of like a constitutional contract theory, where what we're really doing is we're saying you are an institution who is granted authority by your members to engage in good faith adjudication, dispute resolution, and internal governance. Of course, that type of good faith adjudication is subject to procedural safeguards. The implied consent is only to the extent you're exercising this judgment in good faith. And courts, what they get to do is kind of check you on the back end, make sure they get to check your work. If you've done anything really procedurally terrible, that's what you get to check on the back end. So that's kind of how I think about this larger framework in terms of the area of the law. And so when it comes to distinguishing between religious and non-religious, I think it's like, it's not, I think it's the wrong, that's definitely what courts do now. What courts do now is, if it's neutral principles of law under the First Amendment, if you detail it, as you said, painstakingly, like if I say in an agreement women should not be allowed to testify, that a court can interpret. If I say Jewish evidentiary rules will apply, and then a court has to figure out whether or not an interpretation of that is reasonable or valid, we should defer to it. That's what courts is able to do. Under current First Amendment doctrine, we think courts can't figure those things out. They can't extract rules and apply in practice. That's what they're prohibited from doing. If it's neutral principles of law, we allow it. I think it's the wrong inquiry. I think we've just got the wrong framework. It's not what we used to use. I think the correct framework, and again, it gets us away from thinking about the substance of the rule, but more about the institution that we're either deferring, either granting or not granting deference to. I think if we think about the institution, we don't end up as much of this question of religious law versus non-religious law. How do you know? Did that address the core of your question? I feel like maybe I missed it.
Well, maybe. I guess if we follow up with your hypothetical about the clergyman who's dismissed for cause because he gives bad sermons, presumably in your analysis, if there's an arbitration and whatever the outcome is, the court should just say, is it good faith? Was it a good faith arbitration? So, end of story. So you want to preserve that kind of deference.
Yeah, that's right.
But what you don't want to do is preserve deference in sort of my case that I gave you, where the court sort of would seem to be interpreting a contract, and it adopts sort of a really crazy interpretation of the
court
underlying
adopts
law.
really crazy.
Yeah, like by saying, you know, in Islam, only God knows the future, therefore you can't have expectancy damages.
Yeah.
That should be something that should be subject to de novo review.
If a court does that, or if an
arbitrator does it.
Yeah,
I mean,
I don't think it. I think an arbitrator would do something like that. So again, substantive merits. I think that is in keeping with arbitration doctrine. That is all for the arbitrator. Courts don't review the merits of an award, terminations of damages. Unless
they get the law completely wrong.
Right, manifest disregard of the law, even assuming that's still good doctrine in the United States. Yeah, I think, and again, when we talk about things like manifest disregard of the law, the justification for things like that is it so deviates from what the parties wanted in terms of contract that the only way to explain what the arbitrator has done is that they engage in some sort of procedural misconduct. That really what underlies the decision is bad faith adjudication.
But the problem is, in actual litigation, right? The parties are now in strategic relationship, and sometimes, parties will want to engage in bad faith manipulation of the arbitrator, right? So, there'll be about experts, etc. And what I thought you were saying was that you want to be able to maintain this standard of manifest disregard for the law, as opposed to just dismiss because it's religious doctrine. Right. And so that the courts should have an ability to investigate a claim of an arbitrator that this is within, that this is a reasonable interpretation of Islamic law, for example. right? I mean,
Yeah, that's right. That's
so
right.
you still have to have some kinds of conflicts that you think, right, should be almost entitled to absolute deference, and other kinds of conflicts where courts get a sort of a certain set de novo view of it. Maybe Chevron deference is the kind of thing.
Yeah.
And what I'm not exactly clear is what's the principal basis for sorting out these two cases. Whether you want to call them institutional deference or non-institutional deference or religion or secular, it still seems you want to sort out the cases. Right? That for a large majority you want to say absolutely no review, but for some there should be a right to do so because it violates the ante expectations of the parties. Now, of course, ex post, each party is trying to manipulate the arbitrator, right, or the judge. So we can't look at their ex post submissions or expectations.
So I guess I'm curious. My initial reaction is, yeah, it's simple. I think precisely what you mentioned. In any case where we can determine that the arbitrator's decision is so kind of lack of competing theological proposition, like I alluded to before, that would be the standard we would use for all religious arbitration decisions. In the same way we would for any other type of arbitration. We would just subject it to that type of review. Now, obviously, to some, in the context of religion, there may be a variety of competing views, and a court, there's so many, a court can't quite sort it all out. In those cases, they would simply say, here we have no evidence of manifest disregard of the law, like they would do for any other arbitration, which is why manifest disregard of the law is so rarely applied. We do the same thing for religious law, and in each instance, so long as we can kind of find a relationship between the record and the decision of the arbitrators, we would defer, or we wouldn't vacate the award. I think using that standard doesn't require a court to differentiate between religious and non-religious because we're using the same standard for all of it. Did that hit the question?
Well, I mean, again, it still seems that like some cases wouldn't. I mean, I don't know. You're not even looking at, again, the for-cause dismissal of a bad teacher, right? That's purely sort of an aesthetic judgment, and presumably wouldn't even get to the manifest disregard of the law.
Well, I think all decisions would. I just think the likelihood of those decisions even potentially triggering anything would be near impossible. Again, I would just use standard arbitration doctrine. I mean, if we say interpretation of contracts is not for courts, and that's because it's impossible on those things to really get to manifest disregard of the law. Of course, intentional knowing knowledge of the law, and then not only that, but intentional disregard of the law. So when you're dealing with kind of more substantive matters, it's almost impossible to get there. I think you'd have a chance on some procedural matters because they're kind of more detail-oriented, yes/no to evidence, and things like that. But I think it would be the same standard. Well, in any event, I guess I just don't see kind of the torque from the system that would require you'll need to differentiate if you apply the same standard across the board.
Yes?
I had a couple of questions for you. At the end, you talked about three different possible approaches. Reject the whole idea of courts confirming or not. And in the first, option, you said, well, we shouldn't reject this idea because there are certain issues for which the courts are not in a position to decide. And you gave that example of the dispute between the rabbi and whatever. But that's only one kind of example. There are many examples of kinds of cases that are, or hypothetically could be, decided by religious courts that could actually be handled by the state very well. And I'm thinking mainly in the area of family law, marriage laws, and things like this. So that doesn't seem like a good reason to reject the court's ability to, confirm or not that sort of decision. And I don't know if, there's some way of saying, well, maybe certain types of cases, could be decided or confirmed and others not, or, if this would be an option. The other issue has to do with the question of whether the courts should be required or should be able to judge the procedure according to the law of that religion. And I don't know much of anything about Jewish law, but in terms of Islamic law, it isn't as if there is a fixed, body of Islamic law. I mean, there are different schools of law within Islam that not only in terms of substance, but also in terms of procedure, differ from one another. And how is a judge who doesn't have any sort of background in Islamic law? And even so much disagreement even within each school between different interpretations. So this seems to be a nice idea, but is it realistic? Is it a practical option?
Sure. Yeah, those are two important questions. Let me say a little bit about each. In terms of cases where religious arbitration isn't playing a gap-filling role, but is overlapping with the authority of the state, meaning it's a case where, kind of ex ante, both institutions could resolve the dispute. I guess there, I just go back to my core commitment to really individualize religious autonomy. An individual should have the ability and authority via, definitely via private law mechanisms, to pursue their own self-conception, religious identity, and organize their affairs and their perceived religious obligations. And so if they so choose and they have the option, I want religious arbitration to be there so people can decide how they want to be religious. So that's a core commitment of mine. The gap-filling one is, I think, is an important point that shows kind of the way in which religious arbitration is part of, is a key component of the adjudicative landscape. And in areas where they're not playing that role, I still think they play an incredibly important value. They're part of the, as Richard Carnett often says, the institutional infrastructure that makes religious freedom possible. I think without them, people can't organize their affairs. The way in which they understand themselves and understand their religious obligations, and that's something I'm committed to all the way down. In terms of the second question, there's no fixed body of religious law. I completely agree, and which is why I don't want to overstate. I feel like maybe kind of do a short list of time. I don't want to overstate my conclusion. I think my conclusion deals with extreme examples. I think what I really have in mind is to push back against forces that say crazy things like, we all know there are no competing theological propositions here. Let me give you an example of a case, just to give you a sense of what I'm really fighting against. Is this New Jersey case?
You've got a problem in New Jersey.
I'm from Manhattan originally, so whatever. That seed was sown a long time ago. In any event, so you have this high-risk obstetrics doctor, lovely fellow, and I actually got involved in this because I got a call from like a third-party plaintiff in the case. Like, what the hell is going on? I have no idea. Let me try and figure it out. So here's what happens in the case. The name of the case is Abdullah v. Jewish Press. If anybody wants to look it up. High-risk obstetrics doctor. Well-versed both in high-risk obstetrics and in certain areas of Jewish law. And so his entire clientele was Orthodox Jewish women. That's how he made his money, okay? He made his money by being a high-risk obstetrics guy in New Jersey for Orthodox Jewish women. He's in the process of getting divorced from his wife. And she calls up the local newspaper and says there's been a contempt order issued against my current husband for failing to grant a divorce. Who issued the contempt order, a particular rabbinical order. And so the newspaper calls up the rabbinical court and says, did you issue a contempt order? It's like a method of public shaming. So I'm trying to get the husband to give the divorce document, give the Jewish divorce. So the Jewish press, they list all these people in the newspaper, and you're supposed to say nasty things about them, right? Impugn them as much as possible. And so they had the whole list, and so the newspaper calls up the court says, yes, we issued a contempt order against him. So they run his name. Turns out the answer was no, they had not issued a contempt order against him. It was just a mistake, plain old mistake. And so he's got his name listed. And you can imagine what this does to business, right? Like, this is bad news. Like, oh, every one of his clients, the Sabbath morning pops open the newspaper or something, everything pops open, they see the doctor, like, I'm not going to him anymore, right? Right? And okay, so he sues for defamation, and you think he's got a strong claim, right? Like, what on earth? Normally what happens to these religious defamation cases, they die. They die because you said that I, fill in whatever religious slur you want, I take you to court, you respond as the defendant, no, it's true. Now the court can't figure out if the religious slur is true. We have no idea, so they dismiss the case. Here he's got the newspaper nailed, right? He's got no power. What are they going to claim? court says that even though there's no defense of truth here, because everybody agrees what happened, guess what? Still violates the First Amendment. How? I had no idea. I mean, they come up with some crazy things. They agree there are no big competing theological propositions, but you know, the jury would have to understand something about Orthodox Jewish social life, and so that violates the First Amendment. This is nuts. This guy's out $500,000, right? Right? There's no competing theological proposition. This is not like the complex body of Jewish or Islamic law. But there's nothing here. There's absolutely nothing to talk about. This is someone screwed up, somebody published something, and now we're using religion as like some sort of cover here to prevent adjudication of pretty significant financial damage. I don't like that at all. That rubs me the wrong way big time. And I think the answer's got to be that we need to demystify what's going on in these contexts. I mean, this is not so hard. A court can figure this one out, right? At least if we allow courts to treat religious law and the kind of cultural and social context behind it, demystify just a little bit, at least we can protect this high-risk obstetrics doctor, right? That's what I'm getting at. When I'm talking about kind of deep procedural misconduct that we all know is going on, that's when I want to use certain types of arbitration documents to protect people. In most cases, you're right. You'll bring it to a court and the court will say, I have no idea which one's right, and I'd like them to just dismiss it. But in the bad cases, I think we can do a better job protecting people.
All right, we're going to take our last question. Yes?
Well, actually, it is our last. Okay. This question is from Michael and Lena. I want to know if you can share with us any efficacy you see, if any, in family law systems in the U.S. to ensure that Muslim and Jewish women are able to exercise their rights. And if you know if your research has unveiled any collaboration between Muslims and Jews to either support family law systems in their religious communities or to open courses.
Yeah, you probably know more, so go ahead.
So I think partly what I was alluding to and my hesitation with answering this question, and I kept referring to Professor Boyd, is that the issues, I think the major issues are intercommunal, right? And they have to do with how people understand what Orthodox law is, both among Muslims and Jews. And I'm not sure that the state can, and this is why I've been fascinated by this conversation, I'm not sure what the state can do. Like, I actually really agree with Michael in terms of this case we just gave, that it's just law and you should be able to figure it out. And we do know that there are lots of U.S. courts that are implementing various aspects of Islamic marriage contracts, for example, like the delayed dower payment, basically, because they're even like prenups, basically. But in terms of things like custody agreements and the default divorce laws under Islamic law, I haven't seen that stuff being applied. So for the most part, my understanding is that where Islamic law does not directly conflict with U.S. law, it's being applied. But where it does conflict, then there's the problem, right? But that's where the kinds of issues come up. But with Jewish law and sort of the chain wise, I don't know, the issue there is just that if they don't get a divorce decree, they don't get a divorce decree, and they're not divorced. And that's not, I don't see how the state can get involved in that. I mean, they've tried to in New York, but ultimately, we can't force someone to do something, right?
I don't have a ton to say about this. I have very little to say about it, but I think one of the interesting issues is kind of the, well, as a more narrow thing, some of the prenup stuff is super interesting. So whether or not you think of Mars, the delayed dowry is a prenup or not, I think, you know, hard to figure out exactly what it is, but in any event, the treatment of those agreements and by, I don't want to say by contrast, but alongside the treatment of the Jewish prenup, so to speak, there's a recent Connecticut decision that enforced this prenuptial agreement, largely drafted by the Benson of America, which was aimed at basically using a support. Basically, what it does is it requires a husband and wife that have separated for the husband to agree to pay $150 a day as a support payment, so long as he hasn't granted the religious divorce, and this creates a certain amount of financial pressure under the guise of a support payment in order to encourage or press the husband into, I want to say coerce, because then the divorce would be invalid, but just nudge the husband along to doing the right thing.
It wouldn't be invalid, that's what I just told you. It wouldn't be invalid.
I'm sorry. Sincere apologies. Just But in any event, so there you had a Connecticut state court that enforced the prenup. And then by contrast, like back in August, you had a Kansas court that refused to enforce a MAR contract. And there the court engaged in some extraordinary, by which I mean ridiculous, analysis in order to conclude that it couldn't separate the MAR contract from its context. The context did not, the religious context did not live up to standards of due process, and because it was thoroughly confused, it couldn't even figure out how to translate it. Like, this was the most complicated thing in the world. We can't even translate the documents. Completely befuddled by the documents, and ergo comes to the conclusion that it can't enforce the contract. I think one of the important, I mean, these two decisions are just opposites from each other. I think two things can happen going forward. One is, I think we need collaboration in terms of figuring out sophisticated methods of drafting, using kind of contract structure, corporate structures in order to protect vulnerable members of religious communities. I think there's a lot each communities can learn from each other on that point. And then I think one of the important things is to resist the allure of rejection that seems to be sweeping the country, the anti-Sharia laws that are going to make it far more complicated for us to address the answers to these questions. I think if we don't take seriously the religious law where people are coming from, we can't provide them with political solutions that navigate their legal obligations and religious obligations. And I think it's pretty clear that organizations in various communities have come out against this kind of wave of rejection. I think that's super important. Whatever the solution is, which I don't, for a lot of these questions it's hard to figure out, one thing I know for sure, banning religious law to kind of the hinterlands isn't going to help anybody. And I think there is one of the most important areas that we can collaborate.
But I also think the key issue is something that Michael said earlier, which is to understand these religious legal systems as legal systems. So the marriage contracts are just like any other contract. And once you sort of demystify that these are somehow different contracts, you can go a long way to actually getting them enforced, right? So that you can understand these dower provisions as just being any kind of compensation in any contract. To again back up, Michael, since that's where we started now, to end there.
All right, well, thank you very much. We are now going to take